ಇವತ್ತು ತಂದಿರೋದಾದ ನೆನ್ನೆದು ಯಾರಿಗೆ ಏಕೆ ಕಳ್ಸ್ಕೊಡ್ತಾ ಇದೀನಿ ನೀನು ಅಲ್ಲ ಬೈಲಿ ನನಗೆ ಹೋಗಿ ಯಾರ ಕೈಲಿ ಕಳಿಸ್ತಾರ ಒಂದು ಬೇರೆ ತರ್ಬೇಕಲ್ಲ
Then what is that you want? Okay. So dismissed it. Correct. It's not order. Right. Already. Thursday. Tomorrow. What is the urgency? So what is it? What do you want for preliminary hearing or preliminary hearing degree? What is the further orders? What is, which is the year? No, not 2022. Not now. You move it before the regular another bench. Next roster. No, what was the direction? Did we hear the petition? So let it come. It was awaiting. No, not not in this fag end now. Not now. Yes. Move it afterwards, after vacation. Yes. Hmm. Fresh matter.
this time
Fresh matter. Which one you want? 30. At request of the respondent counsel, is this matter after Dasara vacation 2020? So this will go on with the same thing. At request of the respondent counsel, this is matter after the vacation. So we'll hear this matter on merits instead of filing affidavits for affidavits. It won't serve the purpose, right, for what it is being filed. Whether they have paid or not, we have to just see whether the order of the tribunal in granting the interim relief was appropriate or not. So whether he has not paid, it is for him to take, for you to take appropriate action if he has not paid it. Correct. So basic question of saying that affidavit is not correct or anything. If you are ready in the matter, we will take it. Otherwise, yes. What you propose to do? Yes, then after the vacation, we will take it after that. That is regarding some proposal for settlement. This court directed the matter to be listed on 25th. However, the registry has listed it today, listed tomorrow, listed on 25th. Good. So you move memos at 10:30 correctly. Afterwards, when we are taking counsel submissions, page wise correct.
Page number 4, 22, page 5, 28, 32, page 5, 6, 33 to 40.
Request of the petitioner counsel list this matter after the vacation 2020.
Page 7, 41 to 48, 6.
Is that serial number?
Well, it's serial number 39, my lord. I'm appearing for respondent number 2. Counsel is not in station, my lord. Kindly have it after vacation, my lord.
43 at request of the respondent counsel.
39.
That's vacation. 39 20 at request of respondent number 2. 40. At request of respondent number 2, list this matter after the other vacation.
Not with your lordship permission, my lord.
45. GVP ready. At request of learned counsel GVP ready. List this matter after the vacation 2020. Yes.
Lord, sorry to interfere, my lord. Serial number 16, my lord.
16.
Yes, my lord. It is further your lordship has had in part, my lord. We suggested for some settlement on particular day. But after that is matter listed, entire file has been given to the management. Lord, today it is inconvenience, my lord. Any after vacation date may be fixed, my lord. I'll call that managing director also, my lord, to discuss.
After the vacation.
Yes, my lord. Any date may be fixed.
Is heard in part. At request of the petitioner counsel, list this matter after the vacation 2020. Yes.
Obliged.
First. What is this? According to you, the petition of the appeal referred by the respondent is not maintainable under section 89. They have already entered appearance. Yes. Government, to whom you take notice? SCGP to accept notice for respondent number 1. And you? R3 who appears? Harish Bhandari, Learned Counsel, is directed to accept notice for respondent number 3. Issue emergent notice to respondent number 2. Returnable by.
Very important.
When was the order of regrant? You were aware about that regrant in favor of you to the extent of 2 acres? Yes.
Part of the petitioner is applied for regrant of the land in respect of 3 acres 19 acres. In survey number 4 part 2. Respondent number 2 has not filed any application for grant. It's not a rival payment so far as Thailand is concerned. 10791, the Tahsildar granted 2 acres 13 hectares in my favor instead of 3 acres 19 hectares which I have claimed in my application. And granted 1 acre and all to the second respondent without application. That was challenged before me, district judge when he came to know. That is, of course, there is a delay. Now, whether the delay will come into the way to grant relief or not is the short question your lordship has to consider. Now, I have filed an appeal before the district judge. District judge has kept the matter for so many years and ultimately disposed of. Kindly see the other classified hearing. At page 13 and it's 38.
Yes.
Para 12. Please kindly be seen. ಅಂಶ 2 ಮತ್ತು 3 ಒಂದನೇ ಎದುರುದಾರರು ಎದುರೇ ಎದುರುದಾರನ ಗಂಡನ ಪರವಾಗಿ ಜಮೀನನ್ನು ಮಂಜೂರು ಮಾಡಿದ್ದರ ಬಗ್ಗೆ CP1 ತಹಸೀಲ್ದಾರರು ಹಾಜರುಪಡಿಸಿದ ಆದೇಶ ಹಾಜರುಪಡಿಸಿತು. ಸದರಿ ಆದೇಶ ಪರಿಶೀಲಿಸಲಾಗಿ ತಹಸೀಲ್ದಾರರು ಆದೇಶ ಮಾಡುವುದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಜಮೀನು ಮಂಜೂರು ಮಾಡುವುದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ರಾಜೇಶ ನಿರ್ಮಿಸುವ ನೆಲೆಗಳನ್ನು ಹೋಗಿರುವ ವರದಿಯನ್ನು ಸದರಿ ರಾಜ್ಯಗಳು ಎರಡನೇದಾರರ ತಡವಾಗಿ ಹೊಂದಿರುತ್ತಾರೆ. ಸದರಿ ಅವರು ಜಮೀನನ್ನು ಅನುಭವಿಸುತ್ತಿದ್ದಾರೆ. ವರದಿಯ ಪ್ಯಾರ 2ರಲ್ಲಿ ನಮೂದು ತಹಸೀಲ್ದಾರರು ಪರಿಶೀಲಿಸಿ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಮಂಜೂರಾತಿಗೋಸ್ಕರವಾಗಿ ಬಳಸಿದರು. ಅರ್ಜಿದಾರರು ಪ್ರಮಾಣ ಪತ್ರ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದು ಸದರಿಯವರಿಗೆ ಆಮೇಲೆ ಸಾಗುವಳಿ ಮಾಡಿದಂತ ಎಲ್ಲ ಕಟ್ಟದ ತಹಸೀಲ್ದಾರರು ಗ್ರಾಮಸ್ಥರ ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆದು ಅರ್ಜಿದಾರರು ಮೊದಲಿಂದು ಸಾಗುವಳಿ ಮಾಡಿದ ಬಗ್ಗೆ ದಾಖಲಾತಿ ವಂಶವರ್ಷದ ಪ್ರಕಾರ ಅರ್ಜಿದಾರರು ಹಕ್ಕುದಾರರು ಅಂತ ಪರಿಗಣಿಸಿ ಮರು ಮಂಜೂರಾತಿ ಮಾಡಲಾಗಿದೆ. They have not considered whether he has filed an application or not. He has not filed. My specific contention that he has not filed an application for occupancy right at all. Without filing the application, whether the Tahsildar has got a jurisdiction or not to grant the occupancy right is the short question. Following the appeal, ultimately the district judge has rejected the appeal by saying that ಮೇಲ್ಮೇಲ್ದಾರರು ನಿರ್ಮೂಲನ ಕಾನೂನಿನಲ್ಲಿ ಪಠ್ಯ ಮಾಡಲಾಗಿದೆ. ಎದುರುದಾರರು ಮತ್ತು ಎರಡನೆಯ ಪರವಾಗಿ ಮಾಡಿದಂತ ಆದೇಶಕ್ಕೆ ಕಾಯಂಗೊಳಿಸುತ್ತಾರೆ. Ultimately, an operative portion of the order is district judge has confirmed the grant of occupancy right and my appeal has been dismissed. Whether the short question here to consider by this court is whether the district court has got a jurisdiction or not. I have filed wrongly before the district judge in appeal. The appeal is not maintainable. The court ought to have written the file to present it before the proper forum. That has not been done by the district judge. He has dismissed the appeal and my lord, confirm the occupancy right. That is absolutely, my lord, he could not have done it. Kindly see, my lord, section 3.
Okay. Karnataka village operation.
Karnataka inamobilization. Page officer, pollution.
Village operation.
Section 3 to any person. May I pass on?
Yes, yes, it's available.
Any person, 3
Hmm.
to.
Yes, yes.
Any person aggrieved by such decision, that is the Tahsildar's order, may file an appeal to
We file an appeal to the district judge of the district within 90 days of such decision.
power of the deputy commissioner, power of the deputy commissioner to decide certain questions of the appeal. If any question arises, whether the land was granted or continued in respect of the election village office by the state, whether any person is a holder of the village office, or whether any person is an authorized holder, whether any person is an unauthorized holder, the deputy commissioner shall, after giving the party affected an opportunity to be heard and after holding an inquiry in the prescribed manner, decide the question. It is deputy, the first appeal will be before the deputy commission. Here, Tahsildar has passed an order and the appeal is provided before the deputy commission. Wrongly, I have filed an appeal before the district court by wrongly reading, as the clause 2, D2. Therefore, my lord, when the court has no jurisdiction, here two things. One is the Tahsildar has no jurisdiction to grant 1 acre and out to the second respondent.
Correct.
Number 2, third, equally, the district judge has also no jurisdiction. He could have written the file to present it before the proper forum instead of deciding, confirming the occupancy right.
You take notice. SCGP to accept notice for respondent number 1. Issue emergent notice to respondent number 2.
Because so many mentioned. I have produced the record of right. I am still today,
Not
even today, I am in the possession of the property.
Did you have an interim order before during the pendency of the appeal before the district?
Yes.
Where is that order? Yes. Returnable by.
Yes, sir.
Mr. Narayan Swamy, what is this? Wait, 2021, you are before this court, the notification. Correct. You take notice, madam. SCGP to accept notice for respondent number 1 and 2.
Against their own kids, there now in the present in the quarterly ಅವರು ಮರ ಎಲ್ಲ ಕಟ್ಟೋದು ಅವರ ಸ್ಕೆಚ್ಗೆ ಕೂತ್ಕೊಳ್ಳಿ ನನಗೆ ನೋಟಿಸ್ ಇಲ್ಲ ಕರೆಂಟ್ annexation just my lord adjacent
HP Devraju to accept notice for respondents 2 to 3 to 4, 3 to 6. Petitioner counsel to serve the petition papers on the learned counsel. Is this matter? Not at this stage.
No notice, my lord. It's 99 it's one, my lord.
Yes. Next.
I am for respondent number 1 to 3, my lord. Yesterday I filed wakalat for respondent number 1 to 3, my lord.
What is your name, madam? What is-
Girija Patil. Girija Patil.
Yes, we had directed some other counsel to take note.
But the office has given for filing wakalat, my lord. I have filed yesterday. I have filed wakalat for respondent number 1 to 3, my lord.
Like, what you say now regarding this? If they have given you all power, you have to represent and submit your say in this matter. Yes, what is
Yes,
that?
my lord. Yesterday only I received the
You must have
petition copy.
petition
Kindly.
papers. You must have received the petition papers as well, right?
Yes, my lord. Yesterday I received, my lord. Kindly have it on tomorrow, my lord. I will get the instructions from officer, my lord.
This from tomorrow. This is tomorrow. At requesting tomorrow.
Yes,
Council,
please.
Permanent council,
Much
so
obliged.
submits that she has instructions to appear in this matter. Full stop. In light of the submission, the name of H.V. Devraju to be deleted from the cause list as counsel appearing for the respondents number 1 to 3, and show the name of Vidya Patil for respondents 1 to 3 at request of so and so counsel. This matter tomorrow in the preliminary hearing stage.
Please. Much obliged.
What is this office objection? Request of the petitioner, of which time is granted to rectify the office objection.
My lord, in serial number 6, my lord, I have filed wakalat with respect to R4 to R6, my lord.
Yes. Who appears for the
Right.
respondents?
Respondent number 4 to 6, my lord. I received the wakalat yesterday evening, my lord.
What is
I
your-
placed a week's time, my lord.
What is your name, Mr. Counsel?
BS Gautam, my lord.
V.S. Gautam submits that he has instructions to file wakalat for respondent number 4 to 6.
4 to 6, my lord.
Yes. When will you file your wakalat?
Today morning they have filed, my lord. Our colleagues have filed, my lord.
Already filed, huh?
Yes, my lord. Grant me a week's time, my lord. I'll file the necessary objections, my lord.
So and so counsel submits that he has filed power for respondents 4 to 6. Registry to indicate the name of so and so counsel in the cause list. Yes, what is that you are seeking for? What is the mandamus? Okay. Correct. Then there is an appeal provision provided, right? You have to, if you want any enhancement of compensation.
Amount was not given, madam. The amount itself is not paid by the respondent.
So you're not seeking for any enhancement, you are seeking for the compensation which they have determined to be payable to you.
For that, I approach the respondent under sudden declaration and give the representation. After that, the representation is not considered by the authority concerned. Since the damages caused to be brought, which can pay the protector and can see.
What is the project?
Keyboard project. Keyboard to be nothing good one, the columns of the Amraj. Depend on nothing good column. Other project, the channel is passed through the line belongs to the petitioner. Which, they have lost the standing class in there and, and also,
No, at your request, they have put this channel, right? They have put this channel. Then at request,
our line.
at request of whom this?
Operation, for that, project. They use of the land belongs to the petitioner. Thereafter, self-representation was given by the petitioners to pay the amount which is not equal to the agriculture land and also the cost. It was assisted by the concerned agriculture department.
Yes, what you say? Will you consider their representation?
My lord, I'll seek instructions from the office, my lord, and I'll just make my submissions.
Right, Wakalat, you will be having instructions, right?
No, my lord,
That-
I have received the file yesterday, my lord. If necessary, I'll file necessary objections also, my lord.
Not look into the file when a wakalat has been given to you. You know, Alva,
Yes.
what is this matter? What is this? Will you not seek instruction? It's an authority.
Yes, my lord. Kindly have this matter tomorrow, my lord, or day after tomorrow, my lord. I'll just make my submissions.
Tomorrow. Is this matter at request of so and so council tomorrow? In preliminary hearing. Yes. Venkatarama Reddy. Right copy of manuscript portion. What is that manuscript?
Printing license. This is a format, build, or
What is
first
legend?
of it. So name and the site numbers are written in the handletter. Page 29.
What is K and S?
KNS is each other, in respect of two petitioner, that is some clearly is there, I will produce reliable copy of that. But I only produce for reference.
Reference ಅಂದ್ರೆ ಯಾಕೆ ಹಾಕ್ತೀರಾ ಆಮೇಲೆ? Don't file it.
ಇದೇ ಅವರ ಹೆಸರಲ್ಲಿ.
Reference-
I will produce that too. And the third is the copy I will
Office objection reached by the registry at serial number 1 is overruled. To serial number 2, learned counsel for the petitioner seeks time. Learned counsel submits that the legible copy of annexure K and S would be filed within a week. What is that BESCOM copy?
Best of the copy ಕೊಟ್ಟಿಲ್ಲ I will serve a copy on council. Our lord's kindly agency petitioners are all given temporary connection. Now the third respondent had rejected permanent connection to the petitioner 1 and 3. Remaining all not yet paid for permanent connection. That is annexure 3 that page, annexure 3 that page 31. He says only the ground that land has been acquired. I have produced the endorsement PDA and also notification annexure E, that the lands in question which the petitioner's sites are existing are not notified and not acquired. So Lord's annexure P1 is the endorsement is issued by the PDA at page 35. And D and D1 is the endorsement. Saying that these lands are not acquired.
Now you have already a temporary connection, right? Sanction is for the
But now,
main.
to connect the trees, settling to disconnect. Not by kindly issue notice, I will serve a copy of the council. Till then, let them not
Who is the
take
council?
voice the council.
No, who is the council? Who is the standing council? State is not made a party.
One. All the response.
Respond. Now council is very much. You appear for BESCOM. VL Sanjeev is VL Sanjeev direct. HP Devraju. to accept notice for, is directed to accept notice for respondent number 1 to 3. Petitioner counsel to serve the petition papers on the learned counsel.
Let them not take any coercive steps in respect of existing temporary.
Not to take any coercive steps in respect of the existing
Temporary connections in respect of petitioner.
existing temporary connection accorded to the petition premises. Why was this moved? What was the urgency for moving this petition? You did not move the petition when the petition was dismissed in the year 2013. When was the writ appeal disposed? What was the writ appeal was confirming the order of writ petition? Where was that order? Apparent 12. Maintainability of the appeal in view of the appeal was not maintainable. And then why did you seek for a review? It was at your correct. What was that? What was that apparent error? The writ appeal was dismissed on the ground of maintainability. Correct. You sought for a liberty that you will go and file. So writ appeal was not maintainable. You had to prefer an appeal before the apex court, right? SLP had to be preferred. The writ appeal maintainability means you cannot go and file a review petition before the learned single judge. What you have to do is, writ appeal is not maintainable against this order maintainability of the appeal. You have to go before the apex court. Then you sought to withdraw the appeal with liberty to file an application. For what? What is the review you sought? When did you prefer an appeal? 2020 to 2021 is the order. And when did you file this review? 22. Yes, yes. Now, what is that apparent error you want to say? What is the error apparent? That's why the writ appeal was not maintainable. Correct. That's why the writ appeal was not maintainable.
Split petition was dismissed only in the November.
Oh, the first para says invoking 227 supervisory jurisdiction, though it has been stated in the first paragraph, if you look into the other paragraphs of the learned single judge, it means it he has exercised all the jurisdiction under 226 as well. It's not only a supervisory jurisdiction. Look at it. See, the order of the labor court has been challenged. The judicial review is very limited. What is the scope of judicial review in the writ petition?
Without even coming to the value, my lordship, the respondent was given a value that we had sold this for 1 crore 50 lakhs, but they are not produced.
What was the issue before the labor court?
Workman's compensation was not given the lordship.
Correct.
The earlier petitions that which we had filed, there is a direction given that the respondent number 1 and 2 should do clear the views of the workman.
The application was filed under section 33C2 of the ID Act. He sought for certain dues which he had to receive from you.
After we filed the application, the respondent has submitted that 1 crore 50 lakhs it was sold. The building, that is, the property was around 15 acres and 2 guntras, and that building had even machineries also, my lordship. And they sold it for 1 crore, paltry sum of 1 crore 50 lakhs. And in their objection, they claim, in the 1996 objection, they say that their dues are only of 37 lakhs. And thereafter, subsequently, when we find this fresh application, then they say whatever we receive, we have utilized, so therefore we don't owe you any amount. There's no amount to give at all. And on these grounds, without even
see, come to paragraph number 6. Kindly read that. More appropriately over working rules, it was observed that the supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their, and that is whether the subordinate court has assumed a jurisdiction which it does not have, or has failed to exercise the jurisdiction which it does not have, or has failed to exercise a jurisdiction although available, is being exercised by the court in a manner not permitted by law, and failure of justice or grave injustice has occasioned thereby. It was further observed that be it writ of certiorari or the exercise of supervised jurisdiction. So both has been considered, though it has been said is Article 227. None is available merely to correct errors of fact or law, unless the error is manifest and apparent on the face of the proceedings. They are the employees of the SPAR group of companies. Yes. Nothing. No grounds made out, no apparent error. Appeal is dismissed. The delay we will condone because they were wrongfully prosecuting the case. On merits, we will not dismiss. For what? We have already argued. We will condone the delay. We will dismiss the matter on merits. I-1 of 2022 is filed to condone the delay in filing the review petition. The reason assigned is that the petitioner was wrongfully prosecuting in writ appeal, and the writ appeal came to be dismissed with liberty to file a review petition application to review the order in WP, to review the order dated 3/9/2013 in the present petition. The next para. The delay cost is not intentional, but due to bona fide reason. Accordingly, I-1 of 2022 delay in filing the review petition is accepted and delay is condoned. Matter is heard on merits. No grounds made out to interfere. And there is no apparent error. Accordingly, review petition stands dismissed. Petition. What is this? No, you said something, some settlement is going on. What has happened? 14,000. 14,000 ತಗೊಂಡ್ಬಿಡಿ ಸದ್ಯ. It would be, you will at least sustain yourself. 14,000.
On 10/9.
9. Are the same order
For the time being.
for the time being.
That's okay.
I-1 of 2024 is allowed in terms of 14,538 of 2018. ಅದನ್ನೇ order ଅଛି. Same. WP 14,538 of 2018 dated 10/9/2020. ಇದು next ಹಂಗೇನಾ? Same. Yes, Mr. Ajesh Kumar. Yes, you have paid the amount. Paid. So direction disposed of. Subject to compliance of 17B, we have said, right? Learned counsel file for the petitioner filed memo stating that producing the compliance of the order passed by this court dated 10/9/2024 and areas of 17B wages paid to the respondent number 2. The said memo is taken on record. In light of the compliance of the order dated 10/9/2024, I-1 of 2024 for direction is disposed of, directing the petitioner to continue to pay 17B wages. Yes. List this matter in preliminary hearing B group in the week commencing from 21st. Interim order granted earlier is extended to the next date of court. Yes, Mr. Kantaraj, Renuka, Madam. Same, I-1 of 24 allowed. The same other WP 14,538 of 2018. Yes. What is? Further hearing for the Yes. Yes, Mr. Govindraj. You are not entitled for that period. No, because you are already there gainfully employed somewhere. Alva, you have to recall that order. You go and join and work there. But now you're working somewhere else, Alva. That is what you said in the leave letter which you have applied. You said you're working. No, the leave letter which they have produced after joining on 9/9/2024. Okay, that is there. Eager join ಆಗ್ತಿರೋ ಇಲ್ಲ. It's there, ಅಲ್ಲ? Take him into service now. Just a moment. Where's senior? Just a moment. 1 minute. Senior counsel, SP Shankar. SP Shankar, sir. Just a moment. We will pass out. I'll check. Yes. It's 17th. Yes, sir. Have you filed your objections? Today itself. Then
Suppose could go on. She has told me what I have argued is this.
after the arguments of the learned senior counsel for the petitioner was heard, sought time to file their statement of objections. Even today, the learned counsel appearing for the respondent number 1 union seeks time to file their statement of objections on the ground that the statement of objections is ready, but the same has to be vetted by the consent officer. Yes. Finally, 2 weeks time is granted. Yes, this matter in the week commencing from 21st.
Good for one, sir.
Correct.
And then the eldest group, I should not forget.
No, I think the court should not forget. You may not forget, but the court should not forget. So we'll keep it as part, Allah, we'll keep it as parted or we will release from parted. We'll keep it as parted itself. Parted. Parted. This matter on 25th. Senior counsel on 25th. Because we don't know whether we are sitting here or at the benches, then through VC. Yes, 25th. Because Fridays it would be more convenient. Next, the reporting settlement counsel.
Reporting settlement, self-reporting, giving SMS,
Just a moment, that orders matters, we will dictate it in a few minutes. It's ready. On first. This matter on first. Yes, madam. Today, it's listed today. It's listed today. Conciliation, we have referred to conciliation. And no, second list we will take up now. After the dictation for one matter. Yes. No, we are not going to take any other fresh matters today. Only further hearing matters. Yes. Thursday. Yes. This would be listed on Thursday. 26. Agata. Learned counsel for the petitioner submits that the parties that there is a possibility of settlement. To report settlement, if any, list this matter on first. Give me later. Okay. Where did your senior go? On that day, yes.
Slot for the date 9 and 17 but we already put the 9.
Report ugly. He said that he is working somewhere else. ಆ ಕೆಲಸ ಅಲ್ಲ ಬೇರೆ ಕೆಲಸ ಅಲ್ಲ ಬೇರೆ ಕೆಲಸದಲ್ಲಿ ಕೆಲಸ ಇದ್ದಾನೆ ಅಂತ ಅಂದಲ್ಲ.
Yes, already reported that. Report was kept released for documented. But we got for 2 days leave after reporting for leave. He reported on 9/6.
Documents. You have produced certain documents, right? Mr.
Memo, along the memo is on the. Memo. Page number 5.
Correct, that is like. And when the notice, the matter was stay was granted and reinstatement was ordered, that day Kebeta was repulsed.
He was present before the court order. Was present before the court.
And then why was emergent notice ordered?
But he was, and we got to get his conflicts also. He was reflecting. Nagaraj, here.
So he was there on that
He
day.
was there.
And you have filed wakalat only in the month of April, Allah? April. After wakalat from 2019 to 2024. Notice was ordered and then he unrepresented. That is the first.
Conflicts was Nagaraj changed. All incident that was portrayed. Every day he was reflecting the cause.
No, there was a CP. There was a CP, no doubt. There was CP, no doubt. But afterwards, what happened on 12/12/2019? Issue emergent notice was ordered and then stay of the award was granted. Then MS Nagaraj for caveator respondent number and the banto. Then respondent notice was ordered again. Then he was served unrepresented and the Torsiko.
Daily act, they are interacting with each other with respect to this, meeting in the corridor and everything.
He was present that day.
On that day he was present, he was 2019 was very much present, and daily you are also interacting with this issue when you meet occasion corridors.
But one thing is that he sought for implementation of the order. So he was aware about this filing. Anyway, he is not entitled for any wages from 2019 to 24. If you would have filed this application at the first instance, no, they are not taking me to reinstatement, they are not doing anything. Please give me 17D wages, you would be justified. Yes. Kindly be seated. Kindly be seated. Of course, 17D wages. That's all the issue now before this court, only 17D wages. Wages make the merits smell, alva. The petitioner management impugns the order dated 37/2019, orders on I number 2 of 2024. Dated 37/2019 in ID 10 of 2015 on the file of the Labour Court, Chikmagalur, bracket Labour Court for short, filed under section 10A, 10(4)A, bracket of the Industrial Dispute Act 1947, ID Act for brevity, comma, whereby, comma, whereby, why do you put a comma? Whereby the application was allowed. Whereby I will put it. Right. The application was allowed and the petitioner was directed to reinstate the workmen into service and directed to pay a lump sum compensation of rupees 3 lakh, bracket money, 3 lakhs, and held that the workman is not entitled for back wages. You have not challenged the rejection of your back wages, right? This court on 12/12/2019 stayed the impugned award subject to reinstatement. Respondent workman had entered caveat through one counsel. Through counsel MS Nagarajan. However, on 12/12/2019, while staying the impugned order, emergent notice was ordered and subsequently process were taken by the petitioner to issue notice to the respondent and the respondent was served but unrepresented. However, the name of the caveator counsel appeared in the cause list and he represented the respondent. I-1 of 2024 came to be filed by the respondent workman on 20th April 2024 on the following grounds. One, interim order dated 12/12/2019 staying the award was subject to reinstatement, however, so far the respondent workman has not been reinstated. Two, respondent is not working after his illegal termination from service and he is not gainfully employed anywhere. Next, that he is suffering severe hardship due to illegal termination and consequential loss of earning. And he is not a literate person. Next, that the respondent was working. Next one. On 1, 2, 3, and 4. Interim order 1, not working. Members is not gainfully employed. Next, that the petitioner management has not taken back the respondent workman to work, though there was a conditional interim order. And the mandatory provisions to pay wages as prescribed under section 17B of the ID Act 1947. ID Act, when the proceedings is initiated against an award for reinstatement before the High Court during the pendency of such proceedings. This court on on 2/9/2024. Pass the following order. Para number 5, 6, 7, and 8 expert now. 9 of expert. Date 2/9/2000. Pursuant to the order dated 2/9/2024 passed by the court, the petitioner management has filed the present application. I number 2. I number 2 of 2024. Seeking to recall and review the order dated 2/9/2024 passed on I number 1 of 2024, filed under section 17B of the ID Act on the following grounds. 1, that the petitioner management at no point of time refused employment to the respondent workman, comma, the respondent workman himself has left the job with an intention to join pharmaceutical chain that is Apollo Pharmacy. That is Apollo Pharmacy. 2, that the respondent workman was aware of the order dated 12/12/2019, as he had entered caveat to a counsel named M.S. Nagaraja. 3, that the present petition was posted before this court on several dates, that is 7/2/2020, 2/3/2023, and 31/2024, and 28/2/2024. And on all the dates, the respondent advocate has not raised any objections regarding the petitioner having not permitted the respondent workman to discharge his duties. That the application filed by the application I number 1 of 2024 filed by the respondent workman is on 20th April 2024, seeking 17B wages, comma, which is long after the institution of the present petition and order of reinstatement. Next, that the respondent is not diligent enough to move the court, though the matter was listed on several occasions. Next, that the respondent workman is gainfully employed, which is evident from the form of application which is submitted by the respondent workman when he joined the petitioner management on 9/9/2024, pursuant to the order passed by this court on 2/9/2024. Next, objection statement is filed by the respondent workman. ಹಾಕಿದ್ದೀರಲ್ಲ, ಎದಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ? You produce something ಅಲ್ಲ? Affidavit. Correct. Affidavit has been filed by the respondent workman to substantiate as to what transpired on 9/9/2024, pursuant to the 9/9/2024, when the respondent workman reported to duty pursuant to the order dated 2/9/2024. 1. The affidavit reads as under. Extract nothing. With the para number 4, 5, 6, 7. Extract 1, 2, 3 ಅಂತ ಹೇಳಿ ಅದನ್ನು having heard the learned counsel for the party. That arises for consideration is whether the order dated 2/9/2024 needs to be recalled in the present facts and circumstances of it. The right under section 17B is a separate and an independent right available to the workman during the pendency of the proceedings before the High Court or Supreme Court, where the proceedings have been preferred by the employer, against the award of reinstatement in his favor. Against the award of reinstatement. The prerequisites for invoking the section are: 1. The award of the tribunal should have been directed against reinstatement of the workman on setting aside the order of dismissal or unfair termination of service. 2. The employer should have referred the proceedings against such award before High Court or Supreme Court. 3. The workman should not be gainfully employed in any establishment during the pendency of the proceedings. So, as the proof of that, the workman should have filed an affidavit before the court before which the proceedings have been referred. Next. Once these requirements are satisfied, the workman becomes entitled to the wages as contemplated by this provision. And no order of the court, before which the proceedings are pending, is necessary for entitling him to such wages as the statute creates right. If, after the workman has filed an affidavit of non-employment, the employer fails to pay wages as required under this section, the workman may file an application before such court for direction to the employer to make such payment. This court, as stated on 12/12/2019, stayed the impugned award subject to reinstatement. The impugned impugned the interim stay. The interim stay was passed in the presence of the caretaker. And the respondent was very much aware about the order dated 12/12/2019. The fact remains that the respondent did not join the services of the petitioner management. From 2019, the present petition was listed on several occasions, and there was no submission by the respondent about regarding the petitioner not permitting the respondent workman to join the services. The application was filed by the workman under section 17B in the year 2024. No satisfactory explanation is offered for the delay in making an application under section 17B. When the application is filed, when the matter was matured for hearing, the application under section 17B does not explain the delay for making an application for the court to direct payment from the date from when the affidavit is first filed by the workman stating that he is unemployed. The application submitted by the form of application submitted by the respondent workman indicates that for the period of 2018 to 22, up to date, the respondent workman was gainfully employed. Even otherwise, the respondent workman has filed an affidavit before this court only in the month of April 2024. The workman has not made out any ground to award 17B wages. When no efforts were made by the respondent to join the duties of the petitioner management. And accordingly, I number 1 of 2020, I number 2 of 2024, filed by the petitioner management is allowed, and the order dated 2/9/2024 is recalled. The respondent workman is not entitled for 17B wages. Material on record would indicate that the respondent workman has joined the services of the petitioner management on 9/9/2024. The I number 1 of 2024 is allowed. 2 of 20. Orders on I number 3 the limit council for the petition. The judgment which we have relied, that we may not say anything because we will keep it. If we say something because we are not very convinced with that. It's the Delhi High Court judge. It's the service of the. We will continue his. Yes. Yes. Not entitled for 17B wages. Application we will take after further hearing. Dictation we will do after further hearing. is that affidavit filed by the state? What does it say? ನಿಮ್ಮ affidavit ನೀವೇ ಹೇಳ್ಬೇಕು ನಮ್ಗೆ. State ನವ್ರೆ. What does it indicate ಅಂತ ಹೇಳ್ತೀರಿ? ಅರೆ ನೀವು 3 ಸಲ 3 ತರ ಹೇಳ್ತೀರ. Annexure R1 is the craft training certificate course. Duration is for 1 year for mechanical diesel. Duration is 1 year. ಇದಕ್ಕೆ rebate ಏನಿಲ್ಲ. There is no rebate. So 1 year. This is 2022. As on present, it is 1 year. Alva? Then 2 years for revised 2018. Rebate you have given here for 1 year for mechanic. See? So as on the date, that is 3/2/2011, what was the prescribed qualification?
What happened is around.
R2. Is 1 year. Correct.
They give a classification along with page 1. And for some courses, there also
Right.
so for some
Here.
5 minority money. And there are 3 levels. The time is 1 year. Then the data entry operating. Then you know, taking time. One patient cannot get that training. Last year, my training requirement admission. That is the requirement of training.
When was it issued?
They were not even prior to this. Prior to that was the date of the number 1. 3 years, the total period is shown as 3 years. The 3 years, they don't have ITI. So the next is for pressure. 1 year is the basic training. Short close training is 2 years. Next is for ATC code. There is a training called ATC code.
Yes, yes.
But then we're not short training from here training 1 year. And even allowed is out of 3 years for an NAC. Because the course is 3 years. For a fresher, it's 3 years. For an NAC member,
NTC.
NAC member is the one national apprenticeship.
And what is this NTC? For NTC holders and one and the same. So national apprentice certificate and national training certificate are one and the same. So rebate is available at 2 years.
For this reason, they would have already done 2 years of time. For them to come to getting to this, they have to do in ITI. Therefore, they are given. This is the appointment issued by the director employed company. The corporation or the available. The commissioner may not allow asking this case to buy the other. The whole period is 1 year. And for a pressure, basic training like given 1 year. And short floor training. This is the one may not be GS under it. As per the certificate.
No, what is the affidavit what they have filed now? affidavit.
But this they have clarified. It was only clarification whether connection are good. Whether the one is stated without in fact they have proposed.
This affidavit says craftsman training scheme course duration is 1 year for mechanical presently. And apprentice training scheme course duration is 2 years, revised in 2018. Present. So this creates lots of confusion. Now, what is the actual date when 2011? So as on the date of 2011, what was the course available is 3 years, 3 years, but with if an experience of ITC is there, ITI is there, then relaxation of 1 year, 1 year or 2 years, 1 year.
What is the moment that is produced is not the year 2014, 2014, remain the same from 2011. And in the
Now the NIMDO, this revised fixation.
As for the government affidavit.
Refixation and the number has been fixed on the basis. This affidavit of theirs, how should we take it on record?
Still mechanic, 1 ವರ್ಷ course ಅಂತ there's no relevance.
We will not take that. We will not take their affidavit because that is creating more
They have
confusion.
been included subsequently. And it is for them to.
No, correct. There is a rebate available. Now, this is the fact. See, you took a course in the year 1995, 1998. 1998 for 3 years. These people have taken a course in the year 98, 2008, 2009, 2009, 2010. These are the course which they have taken. There the course prescribed is 1 year. After the 3 years course which was available to you at that point of time. And that there was a relaxation for those who had already taken ITI. Relaxation rebate was available for 2 years. So the course available for those who have taken ITI was 1 year of NAC. So NAC certificate that they have possessed is 2008, 2009. No, is it not?
It's not welder, or something like technical assistant, ತಾಂತ್ರಿಕ ಸಹಾಯಕ ದರ್ಜೆ
Correct. Or equivalent.
welder, anything.
Correct.
But within this technical assistant 3, the basic requirement as per what they have called for is 2 years.
Or equivalent. Equivalent ಇದೆ ನೋಡಿ. One second. That is not deviate from the.
First is the 2 years.
ಅಲ್ಲ ಅದ್ರ ಜೊತೆನೆ ಬರೋದು ಅದಲ್ಲ.
Cannot be read in isolation.
It cannot be. That's not. It should be read together.
It not give an implication that instead of the ಕಡ್ಡಾಯ 2 ವರ್ಷ cannot be compromised for 1 year.
ಕಡ್ಡಾಯವಾಗಿ 2 ವರ್ಷದ so and so, then everything is been given ಅಥವಾ then
ಸರ್ಕಾರದಿಂದ ಮಾನ್ಯತೆ
ಅದೇ.
other than this ITC, NTC, NSC
ವಿದ್ಯಾರ್ಥಿಗಳಲ್ಲಿ ಅಥವಾ
ಸರ್ಕಾರದಿಂದ ಮಾನ್ಯ ಪಡೆದ institute in the production and manufacture, automobile, electrical, electronic, fabrication, fitting and metal, ವಿದ್ಯಾರ್ಥಿಯಲ್ಲಿ ಅಥವಾ ತತ್ಸಾರದ ವಿದ್ಯಾರ್ಥಿಗಳು ಹೊಂದಿರುವ ಬಗ್ಗೆ. Ultimately, other than these institutions, MPC, NAC, LPI, all those institutions, other than if any government approved institution is that could be considered. That doesn't mean that now you not should kindly see. Once I am coming within the inviting the application, Karnataka Sahayaka Darja 3, I have a vested right of consideration of my application. Admittedly, the corporation has said that you do not even come under the zone of consideration.
Yes, you were not even having that percentage which was required.
That doesn't all that.
See, there were marks. According to you, there are again one more category of yours. You said mine, they have taken 700 marks. 700 marks, but theirs was taken as 520. Correct. ಅದನ್ನು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. When a certificate was issued to you, say taking 700 marks, you have not stated, no, why have you taken 700 marks to me?
Qualified 3 year certificate. It is my marks. I have done 1 year more than what is required. Now here the fault lies with them comparing the marks of 1 year course of NAC. Now kindly see.
They are equivalent to this 3 years course.
NAC is produced on of the respective candidates produced on 11/9 after 11 years. Now this
Can it be changed?
How we have considered the lot? Your Lordship, my challenge is there is no transparency of consideration of my application. Should not they come in peaceful manner and say that they are trying to fill up the line.
Peaceful manner or
now question is
they have to place the facts on record, whether it is in piecemeal or not in
it
piecemeal.
is interacted. They have to make it clear to this honorable. The challenge is about the method of selection, which is not in conformity with the application which have been called for. That is my responsibility. It is for within no time they have to produce before the court that we have considered this manner. But ultimately, admittedly, what is considered, you Lordship kindly appreciate this. What is considered marks? It is not. Why should I challenge my certificate 3 years, 700 marks? I have obtained some marks. What they have ultimately considered is the marks secured by a candidate who has undergone only 1 year course as against 3 year course. So it is like comparing a PUC candidate's marks, whatever subjects it is, comparing with a degree, 3 years degree.
And then you want to say that PUC immaterial whether you have put on PUC in science stream, commerce stream or arts. Percentage of marks is immaterial. No, percentage of marks is material, whether you have done in science, commerce or in arts. You cannot say science is more difficult. So if I get 80% in science, if you get even 60% in science is equivalent to 80% in arts. No, you cannot go with that.
I have very simple logic. ಈಗ PUC ಅಲ್ಲಿ ಮಾರ್ಕ್ಸ್ ಯಾವುದೇ ಸ್ಟ್ರೀಮ್ ನಲ್ಲಿ ಒಂದು ಪರ್ಸೆಂಟೇಜ್ ಕರ್ತಾರೆ.
Now your ground is ಇಲ್ಲ ನನಗೆ 700 marks I have put on 3 years of certificate. So look at my caliber and then I have become more experienced.
2 years is compulsory. Admittedly, what is considered by marks of 1 year?
You say no. You have to say not that. You have to say 2 years was compulsory, but what they have taken is 1 year. But the marks is immaterial. Marks has been allotted at that point of time itself. But what you are saying is, illa avrige 96 or 86 eno tagondidare, that has been compared anta helodu.
Comparison. Selection process has not been indicated till date. How they are trusting the entire selection list. It is not the case. My respectful submission, having got the basic requirement, I have a vested right of consideration.
Now this is like correct. That is not applicable yet.
No, vested right of consideration. Once my qualification
Is it
You,
conformity?
Andre, you want to say CBSE students are more, if they get marks of, even 80% marks, CBSE marks would go 80% to 100. It is more than what the state
I'm
students.
not saying that. No, Your Lordship, that's what 1 year. First of all, 1 year is consider ಮಾಡಿಕೊಳ್ಳಿ. 1 year ಇದು.
See, 1 year,
consider ಮಾಡಿಕೊಳ್ಳಿ.
1 year of NEC, what he has taken is in light of the ITI which he had already taken, and the rebate was available to him. That is the rebate. It is there in the.
In this regard, my respectful submission, Your Lordship, what would like to drive home the point is 2 years as far as these certificates are compulsory. They could not have short circuit, they could not have considered a person having NAC or ITC of 1 year. This is my simple argument.
Yes, yes.
That for that, my Lord, it is the latest certificate they have produced on 11/9/2000. ITC along with the certificate I have produced, which has not been disputed for 11 years. And it is one and the same ultimately. ITC 34, connection E. That Bhimaraj.
Yes.
Now this is a period of training. Kindly see registration trade business center. Connection E. Suddenly, trade test center, HFT training institute. And the period of training is 1 year. October 2009 to 2010. Now they have produced NAC certificate of that very person, which is available along with the memo produced on 11/9/2024. Otherly, the same Bhimaraj, HFT, NAC National Apprentice Certificate, he has undergone training in HFT. That is why HFT Machine Tools Limited, it is in consonance with the HFT certificate. Connection E marks card. Adu matte, the National Apprentice Certificate is one and the same because 15th October 2009 to 14th October 2010. This is a certificate, this is mark sheet. So there is no additional qualification. Yesterday, it was taught to me, he has done ITC as well as ITI as well as NAC. It is not so. All that he has done 1 year was given along with the documents now produced. It is one and the same. One minute. No. That's what yesterday. ಎರಡು ಮಾಡಿದ್ದೇವೆ ITC. ನಾನು ನೋಡ್ತೇನೆ. Now NAC certificate exactly same. The certificate, whatever they have, 1 year training only. It is now certificate earlier mark sheet, and it is also in HFT machine tools. Next election F. Here October 2009 to 2010.
This is NAC certificate and this is ITI. Which you have produced is ITI, and what he has undergone also after ITI is the National Apprentice Certificate. So 2008 and 2009, November 2008 and 2009. August 2006, in addition to this NAC, he has also done this ITI. That is why he was given relaxation. That is 1 year here and 1 year there, 2 years.
This cannot be.
It is there. See, this is ITI certificate. What you have produced is ITI certificate. You said he has undergone ITI 1 year. This is NAC certificate, which you cannot dispute now. No, see, we are not in a. We are only want to see whether any injustice has been done to you. That's why we have called so many records and all that. It's not that we are just saying something. See,
Kind of consideration.
look at it. Look at it.
That I'm saying this. Now let us take the first candidate.
So whether he could have been selected in place of.
Now we are only sticking to first candidate.
No, I am in fact, as far as I am concerned, my application, the right of consideration, they say that I do not come near the
No,
zone of consideration.
correct, because
That
you
is
did
what
not,
the Supreme Court judgment also says.
because you did not secure the
I
required.
am not, now that 11 years is over, I am not at all getting any satisfaction by asking them to get out. I have nothing. It is they are the employer, they have accommodated them, it is for them. As far as my candidate is concerned, what I am trying to say is that there is, my consideration is not at all there. So, I have vested right of consideration, that is my respect.
Do you say anything, something
because
prejudice, do you say they have some prejudice to you for not considering your application? No. No, is it not your case? It's not your case that they have,
No, when it is not in concerns with the applications which have been, the advertisement, definitely it is a arbitrary risk. It suffers from the vice of arbitrary risk. What else is required? And they do not show that my application has ever been considered. And I have said that it could not have considered along with these three candidates. Again, after 11 years, I have not agreed. They are continued
your
also.
prayer is, insofar as these respondents are concerned.
Yes, because I got a right information, these candidates, please to pass an order.
That is always, that is all the time we pass an order saying that the appointments are always subject to the.
Even they are supposing by the second candidates, if they are saying both ITI as well as NSC, it should sustain. But even one candidate, as far as I am concerned, I have got the information, I have furnished. And that remains challenge for all India. Now they are coming with NSC certificates. But whether this NSC certificate was really considered, the point for it is a point to be illustrated. Because the process of selection, it should have been made clear. Transparency should have been maintained. Now, after 11 years, producing one NSC certificate, no doubt I cannot dispute also. There is some, it is from the authority.
If it is there, it is there.
It is there. Whether these have been mentioned,
No,
then this has gone into their selection process, better. That should have been reflected.
When there are NAC certificate and also the ITI certificate of the respondents, where is the question of saying that they were taken apart from what was notified under Annexure C?
No, that is considered as a point, Your Honor.
Now that has been considered and when appointment.
They are produced. So your documents are produced. That is that. Is there any document that is selection process? I have attacked their selection process. It is for them to demonstrate with clear particulars. That has not evidently not been considered. Now coming to
That is mentioned. Certificates and also. When was it published on? 27/12/2010.
The last candidate.
He was the last candidate. And what was his serial number?
consider money.
Barudela. No, you don't publish, only you publish the select list.
The entire, these are the persons who are eligible for interview, but they are not, all of them are not selected. But they were called for interview. Because that is the cutoff percentage. Because we have to make a list for one is the call. If he doesn't come along in one is the file, they cannot, this is therefore, he could have filed his objection.
Yeah.
Nothing of them is relevant.
And what was the first, what he made an application? Earlier he had made up before this notification. What was that?
That was for assistant artisan. And the same qualification.
So he has been trying his luck all the time from.
There is a judgment of their rights. By referring then he clears before the law. Then there is a judgment of the Supreme Court. All things being equal. We should give preference to
NAC,
NAC was undergone in case of.
in case of. So that was your preference.
Yes, we did not come. If I have work, I know this, 5 days. Reviewing, reverting quite a fresh petition challenge. Regulation.
We did not challenge that.
Challenge and then.
Rejected. Huh?
After that, this advertisement.
What to do, Mr. Sampath?
Signature still there or
Yes, we will refer that. Which is the judgment we have to rely this one? Huh? Which is the judgment you nakait kottidera? Tell one. Change of rule of game.
Now they cannot retrospective change of idea 1 year for Sakata, they cannot do. That is a definitely all those judgments are applicable.
They have not relaxed. They have not relaxed. What they have done, they have taken the preference of this ITI and
contrary to their own advertisements. Your lordship may kindly see.
I'm not counting, may not be.
Two, now my point is, even the first candidate, let us say, the first candidate, 1 year only.
1 year he has given this NAC, right? NAC.
See, 1 year only, there is no difference as far as first candidate is concerned.
So you are not stressing on this one. One year, what you say regarding one respondent number 1? They have produced that annexure F. Annexure E. Annexure E. Of NAC.
1 year.
So now what I want to know, whether he has undergone this ITI. He has gone. Where is that any certificate? For 1 year. See, they have no control about that issuance of 1 year certificate of NAC, correct? You don't dispute. Correct. 1 year course, when will they give this 1 year course? If you have undergone this one ITI, that is not in dispute. Alva. So not producing that ITI certificate, how is it going to affect when he has been given 1 year of ITI and NAC is equivalent to 3 years? That is how it is.
Your lordship is mistaking
No.
It is a period of training October 2009 to October 2010.
They are not disputing that this is the mark sheet pertaining to NAC itself. ITI iddidike 1 year kottidare for them. That is the course which is available to them. There is no. Are they 1 and same?
1 year only. NAC 1 year only.
Why 1 year? Why andre? Because he was given a rebate of this 2 years in light of the ITI which he has undergone.
We are assuming.
Not assuming. Now you come to here, you come to their affidavit and come to that annexure R3 Bani, affidavit of the government. Revised 2018, rebate of 2 years. If it is an ITI. Fitter 2 years, welder 2 years.
This government, they say, Lord, what they are trying to in this mechanic easily. Mechanic easily, duration 1 year because why this government is saying.
Mr. Sampath sir, come here. Come to page number 9 of that affidavit, annexure R3. Fitter is being taken as 3 years. Rebate is of 2 years. Mechanist is taken as 3 years. Rebate of 2 years. Is it not, madam?
Yes.
This is how it is. You know the annexure page 9. That is, this court had to look into all this. Government is not even assisting us. You know by Kalwai. We had to search for rebate. What was the ground available? ಆಮೇಲೆ Turner, ಆಮೇಲೆ Mechanist. 2 years. This is, and they say in their affidavit, this revised 2018 was available as even prior to it. So that is how this court has looked into it. ಅದನ್ನೇ. See, 2000, you have said in your paragraph that is prior to 2018, but you did not say there is a rebate available of 2 years for the apprentice course. You should have said so, right? ಏನ್ ಮಾಡ್ಬೇಕು ಸಂಪತ್?
It is nothing but it's nothing but after.
ಅಲ್ಲ ಅವ್ರು
ಅಲ್ಲ ಅವ್ರಿಗೆ ಯಾಕಂದ್ರೆ ಸಿಲೆಕ್ಷನ್ ಆಗೋದು 18 ಕೊಟ್ಟು
ಹೌದು.
then the government seeks from this employment and training.
It's all fixed ಅಲ್ಲ, ಅದನ್ನ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರ.
2012 ಅಲ್ಲಿ ಈಗ ಸಿಲೆಕ್ಷನ್ ಮಾಡಿ ಆದ್ಮೇಲೆ they are trying to fit in with that. That is not correct. That is why rule of game is sought to be changed by relying upon someone.
That's all. ಆಯ್ತು, ಅದು ನೋಡೋಣ. We will say.
Is central law. Apart from all the decisions I have relied upon.
So this is the one judgment which we will read. Only one judgment we will have. ಅಲ್ಲ ಮೇನ್ ಇದಾಯ್ತಲ್ಲ ಲೇಟೆಸ್ಟ್.
It is central law that it is not open for an employer to change the qualifications of the advertisement which they.
Correct. There,
There,
one ನಿಮಿಷ. There is no change midstream first. ಅಲ್ಲ, it is not midstream. Selection.
2 years.
Yes.
ITI 100% it is midstream. 1 year they are selected.
Yes.
That is one candidate. Any such action would be hit by the vice of arbitrariness as it would right amount to denial of an opportunity to those candidates who are eligible in terms of the advertisement but would stand disqualified on the basis of a change in the eligibility.
You are not disqualified here on basis of.
I'm not being considered.
Say, Mr. Sampath,
Yes.
you were eligible for 3 years, but the marks which you had obtained in the 3 years course was not equivalent to the marks which they had obtained. So you were not eligible. That is all.
Your Lordship, ಒಂದು 3 year course mark ಅನ್ನು can it be compared to 1 year?
No, you
That's all
cannot.
I am
I
saying.
think you should say that you had no locus standi to prepare this writ petition itself. Now, because you were not even qualified, you were notified. You did not fit into the criteria.
It is very clear. 1 year qualification as against 3 years. That is very clear. At least one candidate Your Lordship. It is very clear. On the eligibility criteria, after the same is announced by the employer, having applied for appointment in accordance with terms of the prescribed in advertisement, a candidate acquires a vested right to be considered in accordance with the said advertisement. 2 years ಇದೆ, ನನಗೆ right ಇದೆ, 1 year ನವರು select ಮಾಡಿದ್ದಾರೆ, ನಂದು ಬಿಟ್ಟಿದೆ. So they admittedly that is so considered. This consideration may not necessarily fructify into an appointment, but certainly entitles the candidate to be considered for selection in accordance with the rules as they existed on the date of advertisement. To put it differently, the right of a candidate for being considered in terms of the advertisement stands crystallized on the date of the publication of the advertisement. Any subsequent amendment to the advertisement during the course of selection process, unless retrospective, cannot be ground to disqualify candidate from the zone of concern. This is exactly fixed into my.
This is a settled proposition of law.
Yes.
Correct.
And all those, according to me, they have 2012 ನಲ್ಲಿ selection ಆದ್ಮೇಲೆ ಯಾವ ಕೋರ್ಸ್ ಎಷ್ಟು ಕೋರ್ಸ್ ಅಂತ they try to ascertain. So that itself goes to show that at the time recruitment rule ಪ್ರಕಾರ ಅವ್ರು ಹೋಗಿಲ್ಲ, ಆ ನಂತರ ಅವರು ಮಾಡಿದ process ಅನ್ನು justify ಮಾಡಲಿಕ್ಕೆ 2012 ನ notification ತಗೊಂಡ್ರೆ that is a statement of objection. It's very clear. There's no doubt about it. 100% there is a change in the rule of game, which is impermissible in the light of so many judgments I have relied upon. One ವರ್ಷದ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ, it is okay. It is 100% midstream selection. That's all, madam. And the one other judgment of your lordship that Keshappa, they relied upon has absolutely no applicability. Your lordship is to dismiss and division bench they have relied upon. It's only
They're not even considering that.
Hello, they have relied on. You consider what rely on
Yes,
that.
ma'am.
Yes.
Yes, that's all. The petitioner seeks to challenge. One minute. Seeks to challenge the selection of candidates to the post of technical assistant under CMG category. CMG group, bracketally category. In list dated, the list dated 27/12/2010 under the advertisement number 2 of 2010, appointing respondent 2, 3, and 4, and further direction to the effect that the petitioner is entitled to the selection for the post of technical assistant grade 3 in furtherance of the application dated 26/1/2011. Next one. Necessary facts that needs to be stated are: 1, the petitioner had earlier applied to the post of assistant artisan in the corporation pursuant to the notification dated notification dated 18 notification dated dated 27/10/2010 27/12/2010. Now, first to 2010 bottom. Now, anything?
Made earlier applied to the post of assistant technician under the corporation.
Assistant artisan in the corporation
Sent to the notification
dated 18/5/2003, wherein applications were called for filling up the technical post, the petitioner's application was rejected on the ground that the percentage of marks obtained by him was less than the successful candidates. Writ petition was filed questioning the method and manner of selection of candidates in WP 43727 of 2003, Coordinate bench of this court allowed the writ petition on the ground that, the procedure adopted for selection of candidates by the respondent corporation was erroneous and arbitrary, and on the ground that the preferential treatment was not given to the petitioner, who had obtained 3 years vocational certificate course, that is National Apprentice Certificate, that too in the KSRTC of the KSRTC. The said order was challenged by the corporation in writ appeal 3226 of 2005. The division bench of this court, allowed the writ appeal and set aside the order of the learned single judge, with liberty to the petitioner to challenge the recruitment rules of the respondent corporation. That writ petition came to be dismissed, madam. That writ petition came to be dismissed. The recruitment rules which they have challenged. The petitioner challenged the recruitment rules in WP 2957 of 2010, and the same has been dismissed by this court. Next one. The respondent corporation published an advertisement under notification number 2 of 2010, dated 27/12/2010, comma, inviting application of the eligible candidates to the technical post, comma. The criteria for selection for the post and the prescribed education qualification was 2 years ITI, bracket ITC, NAC, after passing SLC or equivalent qualification. 3. The petitioner possessed 3 years course of National Apprenticeship Certificate from 1/11/1995 to 31/10/2010. 8. The grievance of the petitioner is that the required qualification to do 1, 2, 3 ಅಂತ ಹಾಕೊಂಡು ಆಮೇಲೆ ರೋಮನ್ 1, 2, 3 ಮಾಡ್ತೀರಲ್ಲ ಅಲ್ಲಿ ಇದು ನಾರ್ಮಲ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾಡಿ ನಾನು ಕರೆಕ್ಟ್ ಅಂತ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅದಕ್ಕೆ ಒಂದು ಸ್ವಲ್ಪ ರೋಮನ್ ತೆಗೆದ್ಬಿಟ್ಟು 3 paragraph. The grievance of the petitioner is that the required qualification to the post of technical assistant is compulsory 2 years course in ITC, ITI, bar NAC, motor vehicle, bracket 2, diesel mechanic, auto electrician, welder, sheet metal worker, electronic mechanic, and the said condition is a mandatory one, comma, as is apparent on the face of the notification at Annexure C, calling for the application to the post of technical assistant grade 3, comma, and that the respondent 2 to 4 have undergone training of only 1 year and they could not have been shortlisted, much less, comma, appointed for the post of technical assistant grade 3. Next paragraph. Taking the court to annexures E, F, and G, then it counsel for the petitioner submits that the certificate of respondents 2 to 4 clearly indicates that they have undergone training in respective institution for a period of 1 year as against the basic qualification for recruitment is 2 years compulsory training. And thus the selection of respondent number 2 to 4 as a technical assistant under CMG category is totally in contravention of the recruitment process as envisaged in the terms of the advertisement and recruitment course. Next. Further, that the marks obtained, that the percentage of marks secured by the petitioner in the 3 years NAC certificate course, that too in KSRTC, is equated as against the percentage of marks secured by the respondent 2 to 4, comma, who have undergone the training for a period of 1 year only. And the comparison of marks is highly illogical and could not be adopted by the selection authority. That the competent authority have changed the applicable rule of minimum qualification of 2 years of training in ITI bar NAC as advertised in Annexure C during the course of recruitment bar appointment of respondent number 2 to 4 to the post of technical assistant grade 3, and the action of changing the rule of game during the selection process is impermissible. Reliance is placed on the decision of the apex court in the case of Anil Kishore Pandit versus State of Bihar and others in Civil Appeal number 1566 of 2024, dated 2nd February 2024. The case made out by the respondent number 1 corporation is that the educational qualification prescribed in the advertisement for the post of technical assistant grade 3 is 2 years course in ITI, ITC, NAC after passing SLC or equivalent qualification, and the requirement for taking a course in NAC is SLC plus ITI. The corporation states that the petitioner obtained 3 years course in NAC from 1/11/1995 to 31/10/1998, and during the year 1995, 3 years course for NAC was given without ITI after SLC, and 1 year examination was conducted, and the petitioner has scored 466 out of 700 with percentage of 66.57%, and he was not qualified for the interview. The respondent number 2 have completed NAC course from 15th October 2009 to 14th October 2010 with ITI and scored 451 out of 520 with percentage of 86.73%, respondent number 3 completed NAC from 11th October 2008 to 10th October 2009 with ITI, marks obtained is 252 out of 520 with percentage of 86.92%. And Bhaskar D, respondent number 4, obtained NAC with ITI from 12th November 2008 to 11th November 2009. Marks obtained is 452 out of 520 with percentage of 86.92. The corporation has prescribed eligibility criteria of 2 years, whereas in respect of certain trades, the course itself was for 1 year. That the recruitment is based on the educational qualification, merits and marks secured in the interview. The eligible candidates with the cutoff percentage were called for verification of documents bar interview, and the same was web hosted on 27/12/2010 in as many as 3,232 eligible candidates, which is produced by the respondent along with a memo. This court directed the state government to file an affidavit regarding accreditation of the certificate, accreditation, ACCREDITA, of the certificate course for mechanical diesel bracket 1, comma, affidavit of Sri Nagaraj BK Joint Director, bracket exams, Commissionerate of Industrial Training and Employment is filed to the effect that bracket inverted comma craftsman training scheme, comma, course duration is for 1 year for mechanical diesel. And apprenticeship training scheme course duration is of 2 years, bracket revised in the year 2018, bracket, for mechanical diesel. And prior to the revised before 2018, course duration for the apprenticeship training scheme for mechanical diesel is 3 years. Along with the affidavit, Annexure R1 to R3 are produced. Full stop. Annexure R1 is pertaining to the revised craftsman training scheme in July 2022. Annexure R2 pertains to the revised apprenticeship training scheme in 2018 for mechanical diesel. And the contention of the affidavit states that prior to 2018, the prescribed course duration for apprentice traineeship for mechanical diesel is 3 years, which is at Annexure R3. Perusal of Annexure R3 indicates that for the group of machine shop traders group, the rebate is allowed in the apprentice training to the extent stated in Annexure R3 as 2 years for fitter, 1 year for mechanic, welder, 1 year, which is relevant for the present facts. Admittedly, the petitioner has taken NAC course in KSRTC during the year 1995, and the 3 years course was prescribed without ITI, and 1 year examination was conducted with total marks. It is also not in dispute that the respondents 2 to 4 have NAC certificate for 1 year, as they had ITI, which is the rebate available to ITI for obtaining NAC certificate of 1 year. As stated supra, the course duration for apprenticeship training for mechanical diesel, bracket prior to revised 2018 is 3 years with 2 years of rebate. If ITI, the petitioner, though has obtained NAC with 3 years course, but without ITI, and the respondent number 2 to 4 having secured NAC with ITI, and the rebate available to the respondent is in light of the ITI which they had obtained. In the case of Anil Kumar Pandit, the apex court has observed that, has observed that at para number 8 as under. The law is settled that it is not open for the employer to change the qualification prescribed in the advertisement midstream, as there midstream. As the candidate applied for appointment in accordance with the terms of the with the terms prescribed in the advertisement, acquires a vested right to be considered in accordance with the said advertisement. In the instant case, the right of the candidate was not considered, as he did not have the requisite marks, requisite marks, requisite marks, requisite marks, and he had secured 64.43% as against the cutoff percentage of 96.43%, and he was not qualified for the verification of documents in the ratio of 1:5. The prescribed qualification by the under the notification at Annexure C. Annexure C. There is no change of game of rules, rule of game as contended by the petitioner, and the petitioner has not made out any ground for quashing the selection list for the reason stated supra. And this court passed the following order. This petition is dismissed as devoid of merits.
It's not part of the.
He has completed 5 years. You said he is, there is.
From the date of probation, in the date of probation, it will be 5 years. When the date of probation is 26/5/2008.
26/5, huh? So then he is entitled. If it is 10, if it is 10, he would not be eligible.
I said the rejected, but I had a reason, so I have to say that. I can reject this case, they consider it from the case, from the date of probation. In the date of acceptance of the notification, that is 11/6/2008. Come to 5 years, not 5 years, 15 days, 15 days, 5 years. 15 days.
You have shown the date of probation as 24/10/2008, but it has to be 26/5/2008.
At least 5 years. At the very serial number 27, the date of probation is the date of order will not be with respect to working person to remove them on probation is but their actual date is 26/5/2008.
So it has to be considered not from the date of the order, but the date on 26/5/2000.
Pariksha the Savior Mere Egoista Naka.
Where is that you are reading? First page. Ah.
Following by Pariksha the Savior Mere Egoista. The date on brought on probation.
23/5/2000. 26/5/2008. He comes under which serial number? So he is entitled for gratuity for 5 years.
It comes like 5 years, they take why? When I will take the corporation also has taken considered from 26/5/2008 to 11/6/2013. I held that for 2 years, it did not render the continuous service of 240 days.
That he had.
Excluded those. Then comes 3 years. Everyone said you are not entitled because you are not putting 5 years. But for that 2 years, the controlling authority said that you have not passed an order under section 2A of the Gratuity Act. It's entitling him from gratuity for those 2 years. But supposing I want to deny him gratuity, that period of absence in that particular year, I have to pass an order.
Under 2A.
This absence of yours will be treated as not a continuous service under section 2.
That you have not passed. So he's.
The orders of punishment which I have passed, and I have reduced there, do not reflect that. It only says you are not entitled for any financial benefit.
Gratuity and the
Specific orders that you are not entitled. But therefore, we are not But then, the next is you also to please come to page number 33. The calculation is for 7 years.
33.
33. But in terms of the act, 12,334. This remains
49,810.
12,334
into 15/26. That is 49. 5.
And that was a explain it's very
Next step.
the records. The order basically on probation, training order. That is exhibit R3. I written on the line.
This is.
I this particular it comes at
Training order, right?
Yes, training.
From 27/7/2006 to 26/4/2008.
Yes.
Where does it mention that he doesn't entitle for gratuity during this period?
Already come from the 7. Tarabesi avadiyani. Marku ಮಾಡಿದ್ದಾರೆ. Tarabesi avadiyani. ಸೇವೆಯ ಭಾಗ ಪರೀಕ್ಷಾರ್ಥಿಯ ಸೇವೆಯ ಭಾಗದಲ್ಲಿ ಪರಿಗಣಿಸಲಾದ ಅಭ್ಯರ್ಥಿಯು ತರಬೇತಿ ಅವಧಿಯಲ್ಲಿ ನೇಮಕಾತಿ ಹೊಂದುವ ಮುನ್ನ ಇಟ್ಟುಕೊಂಡರೆ ಸಂಸ್ಥೆಯಿಂದ ಪಡೆದ ಪತ್ರಕ್ಕೆ ಸೂಕ್ತ ಪರೀಕ್ಷಾರ್ಥಿ ಸೇವೆಗೆ ನಿಯೋಜಿಸಿದ ನಂತರ ಉತ್ಪನ್ನ ಪಾವತಿ ಕಾಯ್ದೆ 72ರ ಅನ್ವಯ ಉತ್ಪನ್ನಗಳನ್ನು ಪಡೆಯಲು ಅರ್ಹರಾಗಿದ್ದಾರೆ.
He is not entitled for.
Next one, the order which says next order number exhibit R4 is the order bringing him on probation.
Yes, sir.
Next is exhibit R4. This is the order bringing him on probation, which I pointed
Yes, yes. 26.
It cannot, the condition cannot is mentionable in the clause number 7. ಇವರ ನೇಮಕಾತಿ ಪ್ರಜಾ ನಿಯಮಾವಳಿ ರಾಷ್ಟ್ರದ ನಡತೆ ಮತ್ತು ಶಿಸ್ತು ನಿಯಮಾವಳಿ ಉತ್ಪನ್ನ ಪಾವತಿ ಕಾಯ್ದೆ 72 ಹಾಗೂ ಕಾರ್ಯಕಾಲಕ್ಕೆ ಹೊರಡಿಸಲಾದ ಇತರ ನಿಯಮಾವಳಿಗಳನ್ನು
Yes.
But we didn't say that. And in fact, you also will have to get the contention of the government back to a, for 2 years we will not do that.
Because you have
As
not
far as-
raised,
But calculation is concerned. Something 1,034. Why into 15 for part 26?
how much is that he's entitled?
$35,578. $35,578. Thank you. Dr. Base, very good.
Of
The
this,
English portion is also 35.
34 of, 34 of the repetition.
Only the right one.
Ah.
Only the one. You cannot on the left side, cannot, the page number 33, cannot the calculation is provided.
Ah,
Here, instead of 7 minutes, my submission is there to 5.
ah.
I mean, page number 34 minutes, the period is specified. 11/7 is supposed to be 31/3/2016.
Hmm.
And the later 10.
Yes.
Now she could leave it to the authorities not to calculate the interest, I have not calculated. But I have deposited because the amount when I filed an appeal, but I have to keep refund. Because I have deposited.
We will not disturb the 10% interest, 10%. What is this Sansthe? Now he has to be paid as per the act, right? Yes, Master Naik or Raheli.
I approach it. That shot. If one. If one. Undo read, undo not. Immediately after application on that, later rejected after the controlling. Before the controlling authority, there is a free issue. Now the 2A2 is now not that to that extent, right? That the entire 5 years and all.
They are
Question
entitled.
has proceeded. Let us go to examine other two issues. Whether a KD is entitled for gratuity during the period of 3 years. One. Secondly, my lord, how is value to be calculated in respect of corporate? These are the two issues which are first exam. No, my lord, with regard to KD, KD ಅವರೇನ್ ಮಾಡಿದ್ರೆ ಪೆಟ್ರೋಲಿಂಗ್ ಅಂತ ಇದು KD ಆಡಿಟ್ ಹಾಕಿಲ್ಲ ಪ್ರವೇಶನರಿ ಮಾತ್ರ ಹಾಕಬೇಕು.
All records are available. Annexure R3.
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 R3 ನಲ್ಲಿ page 101 ನಲ್ಲಿ
It says they are not entitled for gratuity for the period of time.
ಆಗುದಿಲ್ಲ ಅದಾಗಿದೆ ಪ್ರಾವಿಷನ್ಸ್ ಆಫ್ ದಿ ಆಕ್ಟ್ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿದೆ ಅದು ಹೇಳ್ಬಿಟ್ಟು ಅದು ಏನು ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಹೇಳೋದು ತಪ್ಪೇನಿಲ್ಲ ಬಟ್ ಆದ್ರೆ ಬರುತ್ತೆ ಇಲ್ಲ ಅಂತ ಆಕ್ಟ್ ನೋಡಿ ದರ್ಶನ ಕ್ಯಾಂಡಿಡೇಟ್ ಡೆಫಿನೇಷನ್ ಆಫ್ ಎಂಪ್ಲಾಯಿ ಅನ್ನೋದು employee means any person other than an apprentice. So apprentice who is employed for wages, whether the terms of such employment and express or implied is any kind of manual or other, or on in connection with our common practice also. Any person, including the apprentice.
Yes.
Now, this training order is not mechanical. There has been examined by the controlling authority upon the applicant. Training order is now section A, page 103, page 101, column 7 more like that. Column 7, the names in there. ಯೋಜಿಸಲಾದ ಕಾರ್ಯಕ್ಷೇತ್ರ ನಾಟ್ ಫಾರ್ ಟ್ರೈನಿಂಗ್ ಕಾರ್ಯಕ್ಷೇತ್ರ ವರ್ಕಿಗೆ ನಾನು ಕೆಲಸ ಮಾಡೋದು ಎಲ್ಲಿ ಅಂತ ಈ ಫೈಲ್ ಟ್ರೈನಿಂಗ್ ಟ್ರೈನಿಂಗ್ ಯಾಕಿದೆಯಲ್ಲ ಡಿಪೋಗಳನ್ನ ಕೊಡಬೇಕಾಗಿಲ್ಲ ಅವ್ರು ಒಂದೇ ಕಡೆ ಕೂತ್ಕೊಂಡು ಕೆಲಸ
is it your contention that you were not appointed as a trainee? Then why are you reading these pages? Why are you reading the definition of employee? You want to say your appointment was not as a
training, but not just getting there.
We are not going to concern us. Your appointment was as a trainee as on in the year 2006. You have not disputed that. You have come along as a trainee till 2008. You were brought on probation in the year 2008. Alva. So from 2000, now you cannot take a different stance. Correct. Now you cannot take a different stance saying that no, I was not appointed as a trainee, but as a regular worker. Is it your contention?
Regular work ಮಾಡಿದೀನಿ. That is what is examined by the controlling authority. ಅದಕ್ಕೆ ನಾನು ಕಾರ್ಯಕ್ಷೇತ್ರ ಅಂತ ಇದೆ. ಕಾರ್ಯಕ್ಷೇತ್ರ ಹೇಗೆ ಬರುತ್ತೆ?
Yes.
Let's control all these gratuity matters are involved in the authorities are not specific. What is their power? The exam to correct the error and examine what is the issue.
Yes.
Is there of this petition and all that. So therefore, what is the error committed by the controlling authority that we look into?
The training order said that you are not entitled for gratuity during the set period of training. Ilva?
Illa. Any order is I should
be go beyond what is there in the report.
I'm sorry for that. So, actually, again, ನನ್ನ ಆರ್ಡರ್ ವಾಪಸ್ ತಗೊಳ್ಳೋದು actually ಇದೆ actually apprentice ಮಾತ್ರ ಇಲ್ಲ and if you look at that connection here, I mean the whatever connection ಅದರಲ್ಲಿ ಏನಂತ ಇದೆ ಕಾರ್ಯಕ್ಷೇತ್ರ ಅಂತ ಇದೆ ನನಗೆ ಕೆಲಸ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಬ್ಯಾಕ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ if I were taking very question of giving back Rashida, can you see that particular portion of the order by the controlling authority? Because controlling authority order ಏನು ವ್ಯತ್ಯಾಸ ಇದೆ ಏನು ತಪ್ಪಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ
ಓದಿ
ಇವರಿಗೆ Rashida ಕೇಳಿದ್ದಾರೆ ಏಕೆಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಲೋಡ್ ಆದ್ಮೇಲೆ ಅರ್ಜಿದಾರರ ಸಾಕ್ಷಿ ಮುಖ್ಯವಾಗಿರುವ ಸಾಕ್ಷಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಅರ್ಜಿದಾರರು 23/4/2006 ನಿರ್ವಾಹಕರಾಗಿ ಸೇವೆಗೆ ಸೇರಿರುವುದು 23/4/2006
So training, he was under training, Tarbeti.
ಐಡಿಯಾ ಹಾಕೊಳ್ಳೋದು ನಮ್ಗೆ ಮತ್ತೊಂದು ಇಶ್ಯೂ ಆಗಿ ನಾವು ಡೇಟಾ ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ನಮಗೆ ಬೇಕಾಗಿಲ್ಲ ಕೆಲಸ ತಗೊಂಡಿದ್ರೆ ಸಭೆ ಹೌದಾ ಅರ್ಜಿದಾರ ಸೇರಿ ಪರಿಸುವಂತೆ ಓದಿರುವ ನರ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪುಗಳು ಓದಲಾಗಿದೆ ಅವು ಪದವಿ ಮತ್ತು ತಾತ್ಕಾಲಿಕ ನೆಲೆಯಲ್ಲಿ ಎಲ್ಲಿರುವುದಿಲ್ಲ ಕಾನೂನಿನ ಸೇವೆಗಳು ಸಂಬಂಧಿಸಿದ್ದು ಪ್ರಕರಣಗಳಲ್ಲಿ ತೆಗೆದುಕೊಳ್ಳಬೇಕಾದ ಹಿನ್ನೆಲೆ ಮೊದಲ ಪಾವತಿ ಕಾಯ್ದೆ ಕೂಗಿನಲ್ಲಿ ಎಂಪ್ಲಾಯಿ ಎಂಬ ಪದದ ವ್ಯಾಖ್ಯಾನದ ಗಮನಿಸಿದಾಗ ಕಾಯ್ದೆ ಅನ್ವಯವಾಗುವ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಅಪ್ರೆಂಟಿಸ್ ಹೊರತುಪಡಿಸಿ ಇತರ ಯಾವುದೇ ನೆಲೆಯಲ್ಲಿ ನೇಮಕಗೊಂಡ ನೌಕರನು ಕಾಯ್ದೆಯಡಿ ಎಂಪ್ಲಾಯಿ ಆಗುತ್ತಾನೆ.
Yes.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ತರಬೇತಿ ನೆಲೆಯಲ್ಲಿ ನೇಮಕಗೊಳ್ಳುವ ಚಾಲಕರ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸಲಾಗುವುದಿಲ್ಲವೆಂದು 2 ವರ್ಷಗಳ ತರಬೇತಿ ಅವಧಿಯನ್ನು ನಿಗದಿಪಡಿಸಿ ಮೊದಲನೇ ವರ್ಷ 2000 ಹಾಗೂ ಎರಡನೇ ವರ್ಷ 2004 ಮತ್ತೆ ಹಾಗೂ ತರಬೇತಿ ಕೆಲಸ ನಿರ್ವಹಿಸುವ ಚಾಲಕರಿಗೆ ನಿರ್ವಾಹಕರಿಗೆ 75 ರೂಪಾಯಿ ಹೆಚ್ಚುವರಿ ಭತ್ಯೆಯನ್ನು ಪಾವತಿ ಮಾಡಲಾಗುವುದು ಮೊದಲಾದ ಷರತ್ತು ನಿಬಂಧನೆಗಳನ್ನು ವಿಧಿಸಿ ಉಳಿಸಿಕೊಂಡು ತರಬೇತಿ ಅವಧಿಯಲ್ಲಿನ ಸೇವಾವಧಿಯನ್ನು ಉಪನಗರದ ಸೌಲಭ್ಯಕ್ಕೆ ಪರಿಗಣಿಸಲು ಹಾಗೂ ಸರಿಯಲ್ಲ ತರಬೇತಿ ಚಾಲಕರಿಗೆ ಉಳಿಸ್ಕೊಂಡು ನನ್ನ ಕೆಲಸ ಫೈನಲ್ ಅಫಿಡವಿಟ್ ಟ್ರೈನಿಂಗ್ ಬಿಟ್ಟು ಏನು ಮಾಡಿಸಿದ ಎಂಟರ್ 2 years I worked the corporation. ಆದ್ರೆ ನಾವು ನವಣೇಶ್ವರ ರಾಶಿಕ್ ಸರ್ ಗೆದ್ದಿಗೆ ಟ್ರೈನಿಂಗ್ ಒಳಗೆ ಅವ್ರಿಗೆ 14,000 ರೂಪಾಯಿ ಯಾಕೆ ಮಾಡಿದ್ರು ಸಂಬಳ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅಂತ ನಾವು ಬೆಳಿಗ್ಗೆ ಹೋಗ್ತೀರ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಯಾಕೆ ಅಂತಂದ್ರೆ ಸಂಬಳ ಜಾಸ್ತಿ ಮಾಡಿದ್ರು ಅವರು ಅದೇ ಕೊಡ್ಬೇಕು ಅಂತೇಳಿ ಸಂಬಳ
ಎಲ್ಲ ಕೊಡ್ಬೋದು ಟ್ರೈನಿಂಗ್ ಇರ್ಲಿ
ಕೆಲಸ ಮಾಡ್ತಾರೆ ನಾವು
ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಸಂಬಳ ಕೊಡ್ತಾರೆ.
75 ರೂಪಾಯಿ ಭತ್ಯೆ ಆಮೇಲೆ ಇವಾಗ 75 ರೂಪಾಯಿಗೆ ಕಾಲೇಜ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಗೆ
Yes.
ನಿರ್ವಹಿಸುವ ತರಬೇತುದಾರರಿಗೆ ಕಾರ್ಯನಿರ್ವಹಿಸದಿರೋದು 75 ರೂಪಾಯಿ ಹೆಚ್ಚುವರಿ ಭತ್ಯೆ ಯಾಕೆ ಬರೋದಿಲ್ಲ ಏನಿಗೆ ಕಾರ್ಯನಿರ್ವಹಿಸೋದ್ರೆ ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಅಂತ ಅದಕ್ಕೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ನಾವು ಹೋದಾಗ ನಾವು ಬೇಡ ಅಂತಂದ್ರಿ ಅದರೊಳಗೆ ಕಾರ್ಯ ಕ್ಷೇತ್ರಕ್ಕೆ ನಾವು ಕಳಿಸಿದ್ದಾರೆ. If I'm a trainee, ಸೆಂಟ್ರಲ್ ಆಫೀಸ್ ಗಳಿಗೆ ಒಂದು ಟ್ರೈನಿಂಗ್ ಕೊಟ್ಬಿಟ್ಟು ನಾನು ಕೂರಿಸ್ಬೇಕು ಟ್ರೈನಿಂಗ್ ಅಂತ ಹೊರಗಡೆ ಕರ್ಕೊಂಡು ಟ್ರೈನಿಂಗ್ ಹಾಕೋಣ 2 ವರ್ಷ ಟ್ರೈನಿಂಗ್ ಹಾಕೋದು ಇದು 23 ಡಾಕ್ಯುಮೆಂಟ್ ಫೈಲ್ ಆಗಿದೆ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಇಟ್ ಇಸ್ ಕ್ಲಿಯರ್ಲಿ ಸ್ಟೇಟೆಡ್ ಎಸ್ ಯು ಗಾಟ್ ಇಟ್ cannot be done as a trainee and apprentice only. You have to go with that. Not their circular, not their appointment order, not their removal order or termination order as acceptance of procedure. You have to go by number of years of service and calculate all over there. They are important. Otherwise, daily you know. You don't carry gun of lava. I think this is you know important. Actually, you want to have to have.
Yes.
ಕಾರ್ಯಕ್ಷೇತ್ರ ಇದೆಲ್ಲ ಒಂದು ದಿಗೋ ಯಾಕೆ ಕಳಿಸ್ತಾರೆ ಕೆಲಸ ಮಾಡಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಆಮೇಲೆ only by right under the act cannot be delayed. They cannot say that he clause in the custody. That you ask me kindly appreciate. ನೋಡಿ ಮತ್ತೆ ಅದಕ್ಕೆ ನಮ್ಮ ಅವಾಗೇ ಹೋಗ್ತೀವಿ.
Yes.
ಆಮೇಲೆ document analysis. How much we can be sent to?
Resignation acceptance, why should we accept, why should we look into that resignation acceptance? Because that is not in dispute. Resignation ತಗೊಂಡದ್ದು acceptance. That is not in dispute. How is it relevant for?
ಕೆಲಸಕ್ಕೆ ಸೇರಿದ ದಿನಾಂಕ ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ರಾಕ್ಟಿಕಲ್ ತರಬೇತಿ ಮತ್ತು ಪರೀಕ್ಷಾ ಅಂತ ಹೇಳ್ಬೋದು. ಕೆಲಸಕ್ಕೆ ಸೇರಿದ ದಿನಾಂಕ.
It's not in dispute that you have.
The date on which I was given employment. ಕೆಲಸಕ್ಕೆ ಸೇರಿದ ದಿನಾಂಕ.
ಮುಂದೆ.
ಅದೇ ಮುಂದೆ ಹೇಳಿ. ಅದೇ ಹೇಳ್ತೀನಿ. ನಾನು ಯಾವುದು ಕೊಡೋದಿಲ್ಲ. ಹೇಳಿ ಆಮೇಲೆ ಪರೀಕ್ಷಾ ಹಾಕಿ. ಒಪ್ಪಿಗೆ ಬೇಡಿಗೆ ಆಕ್ಚುಯಲ್ ಇದೆ ಅಂತ. That cannot be done 2 years period cannot be.
Yes, yes.
So I 7 years back. Then we will have to get to the calculation regarding which is applicable. Not look at any control. The circular will be applicable. Payment of value tax for that.
ಕೊಡ್ಬೇಕು. ಹೌದು act. Act ನಲ್ಲಿ ನೋಡಿದ್ರೆ they are entitled for according to the controlling authority how much? ಅವ್ರಿಗೆ ಆಕ್ಟ್ ಕೆಳಗಡೆನೆ ಬರ್ಬೇಕಲ್ವಾ? ಅಲ್ಲ you said act ಕೆಳಗಡೆ ಆಯ್ತು.
Not for regarding only calculation. I come from the circular was either the circular or the statement in the appointment order or promotional order that you are only over the act of the health of the. There is a provision section
14.
ಅದಕ್ಕೆ ಬಂದು ನಾಸ್ತಿಕ ಕೈಗೆ ಕರೆದು there is industry to settlement. ಎಲ್ಲ ಅದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ವಿ. Regarding payment of gratuity, number of settlement type, section 12 settlement. Union and the parent of data. Our settlement this is settlement dated 18th March 1974. And next settlement, there is a clause with regard to how the calculation gratuity. I will read that particular clause. Gratuity shall be paid in accordance with clause 9 of the memorandum of settlement dated 27/7/1970 and the gratuity regulations or in accordance with the payment of notice of gratuity act 1972, whichever is beneficial.
Correct. That is how it is. Whichever is beneficial.
That is the beneficial ನನಗೆ ಎರಡು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿಲ್ಲ ಅದನ್ನು ಕೊಡಬೇಕು. ಅದನ್ನೇ ಕೊಟ್ಟರು ಕಂಟ್ರೋಲಿಂಗ್ ಅಲ್ಲ.
ಆಯ್ತು. Then 12,334 into 5 years ಎಷ್ಟಾಗತ್ತೆ?
5 years. ಕೊಡಿ ಎಲ್ಲರಿಗೂ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಬೇಕು.
How much is that level?
This reason. This is government order. That those persons were appointed after 2002. And that actually
Which is that government order? And that has been enumerated in their probation?
Many orders. They have not questioned that. But kindly come to addiction. ಸರ್ಕಾರದ ಆದೇಶವು ರಸ್ತೆ ಸಾರಿಗೆ ಕಾಯ್ದೆ 50ರಲ್ಲಿ ಪ್ರದತ್ತವಾಗಿರುವ ಅಧಿಕಾರವನ್ನು ರಾಜ್ಯ ಸರ್ಕಾರ ದೇಶದ ಅಡಿಯಲ್ಲಿ ಅನುಮತಿಸಿರುವ ಅವರ ಪತ್ರದ ಅನ್ವಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ರಸ್ತೆ ಸಾರಿಗೆ ಸಂಸ್ಥೆಯಲ್ಲಿ ಹೊಸದಾಗಿ ನೇಮಕಗೊಳ್ಳುವ ನೌಕರಿಗೆ ನೀಡುವ ಒಪ್ಪಂದ ಪಾವತಿ ಕಾಯ್ದೆ 72ರ ಅನ್ವಯ ಪಾವತಿ ಮಾಡುವಂತೆ ನಿರ್ದೇಶಿಸಿದೆ. ಸರ್ಕಾರದ ಮೇಲಿನ ಆದೇಶದ ಅನ್ವಯ 4/4/2002 ಅನಂತರ ಹೊಸದಾಗಿ ನೇಮಕಗೊಂಡ 22ರ ಅನ್ವಯ
on this, all such appointments which has been issued after 2002, this condition is in. And then accepted this order. The petitioner cannot, in this case, has not questioned. The clause may not either in Annex C stating that this payment of gratuity will be only from the date of probation.
Yes. Yes.
Whereas if the Lordship puts the Annex 3, Annex, sorry, the order of Annex R3, where there is a condition in the training order, like clause number 7,
Yes.
that it will be paid gratuity only from the Pariksha Illadinda, that is not present, it is accepted. The terms and conditions of appointment reported to duty as the training. That particular clause is not questioned.
Yes.
And also, in the provision order also stated that you are entitled to in terms of the act.
Yes.
Aware of it. Therefore, he is bound by the terms and conditions of the appointment.
Yes. Oh.
So therefore, he has, so in terms of the government order, it is all such appointments, yes. What is act says, that I should not pay anything lesser than the act. I have to pay the law in accordance with the act. But more than this, it is that. But here is the case, where the condition of appointment itself is not right. That is not questioned, at an earlier point of time. That's what
It may not have certain clauses. Whether it's appointment data.
ಅಂದ್ರೆ ಕ್ಲಾಸೇ ಹಾಕ್ಬಾರ್ದು ಈಗ.
ಅಲ್ಲ.
ಅಲ್ಲ ಕ್ಲಾಸ್ ಹಾಕ್ಬಾರ್ದು, ನೀವು ಸೈನು ಮಾಡಬಾರ್ದು, ಹಂಗೆ ಏನಿದೆ
ಬರೀ ಯಾವ್ದು ಕ್ವಶನ್ ಮಾಡ್ಬೇಕು, ಆಕ್ಟ್ಗಳು ಇಲ್ಲದೆ ಇರೋದನ್ನ ಹಾಕಿದ್ರೆ ಆಕ್ಟ್ಗಳು ಇದೆ ನನಗೆ ಪ್ರಾವಿಷನ್
ನೀವು ಸೈನ್ ಅಲ್ಲ ಮಿಸ್ಟರ್ ಎಸ್ ನಾಯ್ಕರ, ನೀವು ಸೈನ್ ಮಾಡುವಾಗ ಡಿಸ್ಕ್ಲೇಮರ್ ಅಂತ ಹಾಕೋಬೇಕು. ಡಿಸ್ಕ್ಲೇಮರ್
ಇದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಒನ್ ಸೈಡ್ ಲೆಟರ್ ನಾನು ಡಿಕ್ಟೇಟ್ ಮಾಡಿರೋದಲ್ಲ, ಅವ್ರು ಮಾಡ್ತಾ ಇರೋದು. ಸೆಕ್ಷನ್ 14 of the act. And served under section 14.
Yes.
ಇದರಲ್ಲಿ ನನಗೆ ಬೆನಿಫಿಟ್ ಇದ್ದಾರೆ. Why should I question that appointment? Clause in the appointment. Section 14 ನೋಡಿ ದಯವಿಟ್ಟು. The provisions.
Yes.
The provisions of this act or any rule made hereunder shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act or in any instrument or contract.
Yes.
This appointment letter is a contract. The clause is inconsistent with section 14. Yes. Now, then the not instrument. Now, there is two general word. Even the annexure B, right, only an instrument. It is the form of circular. In this circular, they don't say anything with regard to memorandum of settlement, which gives me a right to claim settlement. Again, and your lordships are aware under the idea, if there is a binding settlement, that can be annulled by way of another settlement. This settlement can be more settlement again.
Yes.
And ಅದಕ್ಕೆ annexure B ತಾವು examine ಮಾಡಿದ್ರೆ and my appointment letter examine ಮಾಡಿದ್ರೆ received by section 14 that you also can be appreciated. ಅದಕ್ಕೆ ತಾವು ದಯವಿಟ್ಟು ನಾಳೆ ಹೇಳ್ಕೊಂಡು ಜಡ್ಜ್ಮೆಂಟ್ ತಂದು ಕೊಡ್ತೀವಿ, ಅದು ನೋಡಿ ತಾವು ಆರ್ಗ್ಯೂ ಮಾಡಿ. ಐ ಆಮ್ ನಾಟ್ ಆರ್ಗ್ಯೂ ಮಾಡೋದಿಲ್ಲ, ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ತಂದು ಕೊಡ್ತೀವಿ. ಡೈಲಿ ಬಂದು ಡೈಲಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಕಾರ್ಯಕ್ಷೇತ್ರಕ್ಕೆ ಕೆಲಸ ತಗೊಂಡು 75 ಬೇಡ ಕೊಟ್ಕೊಂಡ್ಬಿಟ್ಟು 2 ವರ್ಷ ದುಡಿದಾದ್ಮೇಲೆ ಉಳಿದ ಸೇವೆಗೆ ನಾವು ಗ್ರಾಜ್ಯುಟಿ ಕೊಡಲ್ಲ ಅಂತಾರೆ. ನೀವು ಮಾಡಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ 6 ಬರೀ ಓದಿದ್ರು ಸಾಕು, ಅವ್ರು ಏನ್ ಕೆಲಸ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ನೋಡ್ಬೇಕಾದಾಗ. ಸೆಕೆಂಡ್ಲಿ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿಸ್ ಸರ್ಕ್ಯುಲರ್, ಇದುವರೆಗೂ ಯಾವತ್ತೂ ಇದು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ. ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತಂದ್ರೆ
ನೀವೆಲ್ಲ ಕೂಡ ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಟುಮಾರೋ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಯ್ತು, ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಸೆಕ್ಷನ್ 40 ಬ್ಯಾಕ್ ಬೈಂಡಿಂಗ್ ಅಂತ. ಪರ್ಸೆಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಡ್ಮಿಟೆಡ್ ಅಮೌಂಟ್ ಕೊಡ್ಬೋದು ಈಗ 5 ವರ್ಷಕ್ಕೆ 2 ವರ್ಷಕ್ಕೆ. ಅದಕ್ಕೆ ನಾನು ಈ ಸದಾಯಿಸಿದೆ ಪೆಟ್ರೋಲಿಂಗ್ ಅಥಾರಿಟಿ ಒಂದು 5 ವರ್ಷಕ್ಕೆ ಕೊಡ್ಬೋದಾಗಿತ್ತು. ಅದನ್ನ ಕೊಡ್ಲಿಲ್ಲ. ನಾವು ಪೆಟ್ರೋಲ್ ಇವನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಆಫ್ ಗ್ರಾಜ್ಯುಯೇಟ್ ಪರ್ಸನ್ ಆಫ್ ದಿ
Yes, next. We are hearing this vacating application. So we will, this vacating application, we will dismiss this application, list this in B group. No, because we have to take a contrary view to what I have written in my code for my judgment. I have to take a different view now. That is not permissible, right? It becomes for imperial. I should take a different view now, which I have already passed in one repetition. And that was not brought to the. So I may have to take a different view now. That may be not appropriate. So we'll dismiss your application for vacating because it is as good as hearing the matter on merits. And we'll issue rule, let the matter come in the usual.
It's conduct is.
Your lordship would, your lordship, without going into this, or data of the, right, that the corporation is gone with the inquiry. Gone with the inquiry.
But then what happened?
The report them, ultimately, they can't impose punishment. They hold an inquiry and they pass, the inquiry report should be, but they may not impose punishment. So they are not the authority of.
No, but then, but there are no proceedings being initiated by you right now. Then what is this? Then what happens is now they have given, they're saying why disciplinary action should not be taken.
The recommendation when they issued an observation note, what we should have done is we should have commenced the inquiry procedure.
Then there are
articles of charge. I should have informed them that we have already initiated proceedings and the end result we would inform.
yes. So then even it is not too late now. You can do that inquiry proceeding.
If it open may not be.
Now, what is the stay granted now by this court?
Pursuant to observation note connection B.
So then they cannot even do inquiry.
My God, it's just why. And I know where are they having the issue?
I am the one who.
No, so this vacating stay, we will dismiss this application. No, that would not again be available in light of my judgment, which I have passed now. The very principle.
Not faster than running there. I'm not receiving not the monthly report from the complaint authority.
Or will not, may I request that them hold the inquiry, and not to pass file.
Not to pass, we will listen for consideration.
Consideration. Because either way, either they have to vote or I have to vote, either way. But what happens, ultimately, the jurisdiction is upheld,
Somehow I feel now, apart from what order have passed in the earlier repetition, see, there are two complaints now. There are two complaints filed, one before the Lokayukta and one before the corporation. Before the Lokayukta has got an independent power to say that what are the proceeding, whether he can initiate. Now, in your case, it is a disciplinary inquiry. But now, I have to go against my own judgment then. Then inquiry, what is the order now passed by this court? Staying of the further proceedings, then I have to modify that order, right? I have to modify.
Your Lordship can fix it.
Not the judgment. But
MD, managing director, thought said, in terms of cases, if the rules are met.
Request your Lordship to. Division bench, where I page number 87.
That's the matter. It's not a appears. That's the reason why. That's the thing. You complete inquiry, fail the inquiry.
The purchase paid was never required for the qualification.
That is the seriousness.
And no permission is taken from the higher authority
That is the seriousness.
for purchase. In fact, she is not the only one, but who sanctioned the amount, the DOA. Account officer is also. Yeah.
the articles of charges were issued by the Lokayukta.
Yes.
So then, under section 12 to 3.
Your Lordship. Very good.
Hmm.
And the Lordship can replace the.
And then what happens after we receive? Then that has to be forwarded to them. Then they would take that report as an inquiry report only, right? We will modify that order. Yes, that is what.
Page 89.
We are not considering on merits. Now already a complaint was individual complaint. That is a separate complaint given by the concerned person to the Lokayukta. They have got authority to consider look into the complaint. What happens?
On the completion is gone by the division bench is admitted by law. Similar case, there also a complaint was given to the.
We are not passing any orders on merits. We are going to modify the order of interim order granted by this court, saying that let the inquiry be conducted and let the Lokayukta file a report before this court. What this one? What is that? This one? No jurisdiction to conduct what? See, it is not on the basis of an proceedings which was initiated in the employment. There is a complaint lodged. They have not even started any inquiry. Aur madidara? Otherwise, we will dismiss your petition saying that let the respondent number 1, that is respondent number 1, send a report to the so and so. That is what. Send a report to the corporation. And the respondent number 1 to take a course.
That this argument is open to them.
We'll quash the articles of charges also what they have done. We will quash that orders also. You just hold the inquiry. We'll quash that orders of articles of charges which have been issued against. What is this piecemeal, madam? You come and say one thing, you come and say another thing. So that's why this court did not want to take up this matter because we understood that. We understood. What is that your senior would submit apart from what you said?
Jurisdiction to hold an inquiry because it is not Yeah, she is not a public servant. No publication means the CCA, KCS, is not applicable. So, when the government is government, it is not a government
What
service.
to do,
not
what,
a
how to solve this
government
problem?
When it is not governed by CCA.
See, I have to, as you said, this is a judgment of mine, wherein it says the Lokayukta had no jurisdiction to conduct any inquiry.
ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ತಾವು ಕೇಸೆ ಅಪ್ಲಿಕಬಲ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ ಹೋಲ್ಡ್ ಮಾಡ್ಕೊಂಡು ಎನ್ಕ್ವೈರಿ ಕರೀದಾಗ ಹೇಳಿರೋದು.
It's not applicable. Correct.
That's what your lordship is para Satara D. The lordship left over the decision to the district authority.
Para D. We will release from parter anyway. Release from parter. Won't serve the purpose. Let the vacating be there. You press it, yes. You press. Release from parter. The petitioner is unable to substantiate her contentions. Release from parter. Because I have to take other view also is difficult, but the very view she is not allowing. Release from parter. It's the week commencing from 14th October. The dictation of Madhyana Hakoli, dictation first, and then further hearing. Yes. You're going to carry the beautiful thing.
No, I appear for the respondents in the matter, Your Lordship.
Mr. Gopala Murthy, how is correct? How is the petition maintainable?
But for that matter, and they are refused to endorse the CC.
This petition is contested by only petitioners 2 to 9.
Please, madam.
Why they have settled? Oh,
They have settled the matter.
they have given you representation, it seems, Mr. Consul.
I'm sorry, my lord. I'm sorry, my lord. They have not given. Kindly see the ink page, page number, running page number 8 in the writ petition, Your Lordship.
There is a case, my lord, since petition is pending.
Allah,
since
Mr.
2021.
My lord, they have,
Allah, Mr. Consul, when did you give your representation? When was the writ petition filed? Just look into the dates. ನೀವು ಅವ್ರು ಹೇಳ್ತಾರಂತ ಹಾಕ್ಬಾರ್ದು. You should also look into the.
Thereafter, they have gone, my lord. On 22, my lord, on.
What is there?
They have filed petition.
Huh.
But thereafter, they have filed the.
Right, is it permissible? First you have to approach them, right? First you have to approach them. Let them consider your. You consider their representation, Mr.
my lord, they have not yet given the representation, my lord. If the writ petition, they have made the false allegations against the institution, saying that they have given, they have approached.
This is the representation requisition letter which they are filing before the court, saying that they have given a representation to you on 22/7/2021. What is there? Maybe after filing of this.
But that is not the part of the writ petition, Your Lordship. That is the reason I don't have that copy. That is the reason I'm making.
You must be having the records with you, right?
Please,
They cannot place anything which has not been given to you. Allah.
please. If that is the case, we'll
Take the document.
You just verify from your concerned officer, where is that?
please.
Learned counsel for the petitioner files memo along with the copy of the requisition letter dated 22/7/2021. Yes. The said memo is taken on record.
May I make one submission, Lordship?
Someone seeks to verify. Yes, what is that?
My lord, if that is the case, my lord, if there is an endorsement, my lord, we will examine and we will pass the suitable orders within a period of 8 weeks, Your Lordship.
We'll dispose of this writ
Please,
petition.
Your Lordship.
We'll dispose of.
Please, ma'am. We will examine and pass the suitable orders, my lord.
Who are you? And who is he? And the respondent number one is the person who was employed. Then how are you concerned? Correct, principal avre. You are a contractor. What is this, Mr. Consul? ಅವ್ರು ಹೇಳ್ತಾರೆ ತಗೋತೀನಿ ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ ನಾವು you are submitted to respondent number one, right? Then petitioner is seeking for a writ of mandamus or directing the respondents. Petitioners, ಎರಡು petitioners ನಲ್ಲಿ same prayers, huh? Petitioners in both the writ petitions, huh? Are seeking for a writ of mandamus directing the respondents to pay the minimum wages in pursuance to the notification dated 6/1/2017 and fixed wages and fixed minimum wages. Petitioner, in order here first.
I'm sorry, Your Lordship, may I make one submission, Lord? But that is not the part of the writ petition. I will examine, will kindly have it after vacation, Lord. I'm sorry, my apologies, Lord. Kindly have it after vacation. We will examine in the institution.
Order hangge irli. First order memo is taken on record. Respond. No, we have not heard it, please. Yes.
Because even that copy is not furnished for me, Lord. That is the reason I made. I'm
Taken
sorry.
on number. Petitioners, respondent 6.
Respondent 6 to verify.
Time to verify. This is matter after Dasara vacation 2020. In the week commencing from 21st. Yes. Dictation will take it up in the
I'm
afternoon.
sorry. I'm sorry, Lord.
Yes, Senator. Yes. Tomorrow. Other than filing first. Dictation, where is that answer? Serial number 1. Serial number 1 will dictate in the afternoon first half. What happened of settlement? No proposal. Nothing. Yes. Other matters we will only take further hearing matters, not other matters. Any urgent matters you all can mention. Which we will not take other matters. 42, after completed, the vacation. You can't give you date, the week commencing from. ಮಧ್ಯಾಹ್ನ ಏನಿದೆ? 2:30 ಏನಿಲ್ಲ. Mr. Alva, please come at 3:45. We have one dictation matter now. After that, we will take one. Yes, at 3:45, yes. What settlement, sir? Being aggrieved by the judgment and decree dated 5/1/2017, passed by the first additional district and session judge, Bangalore, Rural District, dated 5/1/2017, in RA number 13 of 2016, on the file of First Appellate Court, confirming the judgment and decree passed by the Principal Senior Civil Judge, Bangalore, OS number 591 of 2009, dated 17/12/2015, on the file of the Senior Civil Judge, Bangalore, Rural District, herein referred to as trial court. Parties herein are referred to as per the Putkathira. Take some time. Chair for your. Parties herein are referred to as per the rank to the trial court for the sake of. Plain governments. One moment. Plaintiff's grandfather, Amir Khan, has two children, has two sons, namely plaintiff's father, Abdul Majid, Khan, and Abdul Wajid Khan, the second son, and a daughter by name Zubida Begum. Plaintiff's grandfather, Amir Khan, had acquired several properties during his lifetime. See? After the death of plaintiff's grandfather, Amir Khan, his two sons and daughter have divided all the family properties under a registered partition deed dated 17/7/1948. A scheduled property which is the plain scheduled property bearing survey number 80, measuring 2 acres 28 guntas, was allotted to the share of the plaintiff's father, comma, inverted comma. B scheduled properties was allotted to the share of Zubeda Begum, and C schedule properties are allotted to the share of Abdul Wajid Khan. A schedule properties of under the registered partition deed dated 17/1/17/7/19 as A, B, and C properties. And in the registered and in the partition, A schedule. Next. Registered partition deed, that in the registered partition deed, there is a misdescription in respect of A scheduled property, though was allotted to plaintiff's father, Abdul Majid Khan. Majid ಗೆ underline ಮಾಡಿ, Majid. Abdul Majid Khan. Being the first son of Amir Khan, has wrongly been written as Abdul Wajid Khan, W-A-J-I-D. Wajid Khan, Wajid kare underline ಮಾಡಿ. Though Abdul Wajid Khan was the second son of Amir Khan, and towards his share, C scheduled property was allotted. And B scheduled property was allotted to the daughter, Zubeda Begum. That the plaintiffs requested the defendants to execute the rectification deed, and in spite of several requests, they have not come forward. That the defendants, that the cause of action for filing the suit arose in the month of March 2009. 2009, partition deed dated very 9, when the defendants in collusion with the other estate agents attempted to alienate the scheduled property, taking advantage of the illegal revenue entries standing in their name, and based on the misdescription underline in the registered partition deed, the plaintiff, paragraph Roman, the plaintiffs sought for declaration that the plaintiff's successor in interest, Abdul Majid Khan, in interest of Abdul Majid Khan, are the owners in possession of suit scheduled property. On notice, the defendants appeared and filed their written statement. Inter-alia contending as under government's in written statement. That after the demise of Amir Khan, his properties were inherited by his two sons and one daughter, namely Abdul Majid Khan alias Arifullah Khan, Abdul Wajid Khan and Zubeda Begum. That the family properties were partitioned among themselves by registered partition deed dated 17/7/1948. And as per the partition, the properties were partitioned as per the partition deed. The properties were partitioned in the following manner. Abdul Wajid Khan, the grandfather of the defendants, was allotted suit scheduled property measuring 2 acres, 28 guntas in survey number 80, and another property measuring 32 guntas in survey number 122/2, both situated at Medimalla Sandra village, Anu Gondahannahalli, Hubli, Hoskote Taluka. B. Abdul Majid Khan alias Arifullah Khan. The father of the plaintiff was allotted a house bearing number 81, situated at Hoskote Taluka. C. Zubeda Begum was allotted agricultural land measuring 3 acres 31 guntas in survey number 130/2 of Hoskote Taluka. Next. Normal number. After the demise of Abdul Wajid Khan, his only son, Saifullah Khan, that is the father of the defendants, inherited the properties, which included the suit schedule. And after his demise, that the suit schedule property allotted to the share of the grandfather of the defendant, Abdul Wajid Khan, after partition, the khata continued to remain in the plaintiff's father's name, that is Abdul Majid Khan, until 1992-93. And in the year 92-93, the plaintiff's father made an application to the revenue authorities to transfer the khata in his name with respect to the scheduled property. Plaintiff's father submitted that in the year 1992-93, defendant's father made an application to the revenue authorities to transfer the khata. Objections were called for the transfer of Khatha. At that time, neither the plaintiff nor any other person raised objection for transfer of Khatha with regard to the scheduled property. Shaifullah Khan, next para. Shaifullah Khan, the son of Abdul Wajid Khan, was cultivating and in possession of the suit schedule until his demise in the year on 24/3/1997. And the suit schedule property is bequeathed by way of will in favor of the defendants under registered will dated 9/10/1996. And after the demise of Shaifullah Khan, the defendants are lawful owners in peaceful possession of the suit property. Shafiullah Khan. सही संपन्न Shafiullah Khan. that's अच्छे था. The trial court, on basis of the pleadings, framed the following issues. Page number 34 of the paper. The trial court on the basis of the pleadings, oral and documentary evidence, arrived at a conclusion that the plaintiff has proved his title and possession over the suit property. 1, 2. And by the judgment and decreed the suit, declaring that the plaintiff is the successor in interest of Abdul Majid Khan and owner in possession over the suit property, and restrained by an order of permanent injunction, and restrained the defendants by an order of permanent injunction for interfering with the plaintiff's possession over the suit. Aggrieved, the defendants preferred appeal before the first appellate court. The first appellate court, while reconsidering and reappreciating, the first appellate court concurred with the judgment and decree of the trial. This court, while admitting the appeal, agreed the defendants have appealed. This court, while admitting the appeal on 23/10/2018, framed the following substantial question of heard the learned counsel for the appellant and the learned counsel appearing for the respondent and review the judgment and decree of the courts below and the material and the original records and the original. Learned counsel for the appellant would urge the following grounds. The judgment and decree of the courts below in decreeing the suit of the plaintiff is contrary to law, facts, and material on record, and the same is liable to be set aside. That the courts below have failed to appreciate the partition deed at exhibit. At exhibit P1 dated 17/7/1948 and misdirected in itself in misconstruing exhibit P1 and arriving at a conclusion that the suit schedule property was allotted to Abdul Majid Khan alias Arifullah Khan, father of the plaintiff. When exhibit P1 when
That the courts below have failed to appreciate the partition deed at exhibit P1 dated 17/7/1948 and misdirected itself in misconstruing exhibit P1 and arriving at a conclusion that the suit schedule property was allotted to the Abdul Majid Khan alias Arifullah Khan, father of the plaintiff, when exhibit P1
and the document at exhibit P1 clearly indicates that the suit schedule property along with survey number 122/2 was allotted to Abdul Wajid Khan, the grandfather of the defendants. That the courts below have failed to appreciate the mother deed, which is paramount in granting a relief of declaratory suit, and wrongly proceeded on an assumption and misconstruing exhibit P1 to arrive at a conclusion that the plaintiff's father, Abdul Majid Khan, alias Arifullah Khan, was allotted the suit schedule property under the partition deed dated 17/7/1948, exhibit P. For contra, the learned counsel appearing for the respondents would vehemently contend that the father of the plaintiff, Abdul Majid Khan, being the elder son of Amir Khan, was to be allotted A scheduled property in the partition, and B scheduled property was allotted to daughter Zubeda Begum, and C scheduled property was to be allotted to Abdul Wajid Khan, father of the grandfather of the defendants, and that in the registered partition deed there was a misdescription of indicating the name of Abdul Wajid Khan instead of Abdul Majid Khan, father of the plaintiff. Father of the plaintiff is always Majid. Majid Khan. And that, that the courts below concurrently have held and perused Exhibit P1 and rightly arrived at a conclusion that the suit scheduled property was allotted to the father of the plaintiff, and there is no misconstruing of Exhibit P1 as contended by the appellant, that the concurrent findings of facts recorded by the courts below does not warrant any interference, and the substantial question of law needs to be answered against the appellants. This court has taken. This court is conscious that the concurrent findings of facts recorded by the courts below cannot be interfered with unless warranted by compelling circumstances, compelling reasons. when the findings of the first appellate court and the trial court are shown to be perverse, the court can certainly interfere with the findings of facts recorded by the courts below, as held by the apex court in the case of Mahesh Dattatray Tirthankar versus State of Maharashtra, reported in 2009, Part 11, SSC 141. The phrase, inverted comma, substantial question of law, inverted comma, as occurring in amended section 100 is not defined in the code. The word substantial, comma, as qualifying, inverted comma, question of law, inverted comma, means of having substance, comma, essential, comma, real, comma, of sound worth, comma, important or considerable. Where the courts below did not consider the material document in proper perspective, it is incumbent upon the appellate court to reappreciate the entire oral and documentary evidence. In the instant case, the first appellate, the trial court, in a very cryptic order, misconstruing Exhibit P1, arrives at a conclusion that as per Exhibit P1, the suit property is allotted to the share of the plaintiff father, plaintiff's father, and relies upon the cross-examination of DW1 to come to a conclusion that DW1 has admitted, come at a finding that the A schedule property or in the partition is being allotted to the father of the plaintiffs, as DW1 in his cross-examination has admitted about the partition among the children of Amir Khan and the suit property being fallen to the share of the plaintiff's father. At this stage, the cross-examination of DW1 needs to be looked into. Needs to be looked into. wherein DW1 has categorically stated that the suit schedule property and survey number 122/2 was allotted to Wajid Khan, Abdul Wajid. The entire dispute revolves upon Exhibit P1, the partition deed dated 17/7/1948, and the construing of Exhibit P1 by the courts below. The perusal of Exhibit P1 clearly indicates that the suit schedule property had fallen to the share of the defendant's father, Abdul Wajid Khan. And this description recitals in Exhibit P1 is not disputed by the plaintiff. On the other hand, in clear, unequivocal terms, the plaintiff in his pleadings has stated as under page 8, marked portion. Relevant portion of the para number 8. The relevant portion of the pleadings, government, is as under para number 8, underline value 2, underline. Section 58 of the Indian Evidence Act, 1872, clearly postulate that the things admitted need not be proved. Though proviso to Section 58 of the Evidence Act gives full discretion to the court to require the facts admitted to be proved otherwise than by such admission. In a suit for declaration, when declaratory rights is being sought, the burden is on the plaintiff to establish his title and to discharge his burden in an independent manner. Few sentences or few admissions in the written statement or in the cross-examination of the defendants cannot be an advantageous to the plaintiff to have a decree in his favor. When there was categorical pleading in corroboration with Exhibit P1, which clearly indicated that the suit schedule property was allotted to the defendant's grandfather, Abdul Wajid Khan. The courts below have misdirected itself in perusing Exhibit P1 and the pleadings of the parties. When the plaintiff's own averments are to the effect about misdescription in respect of the allotting of suit schedule property to the father of the defendants. The trial court and the first appellate court would not have arrived at a conclusion that the suit schedule property was allotted to the share of the plaintiff's father. The first appellate court, being the last fact-finding court, ought to have borne in mind that the first appeal is a valuable right of the parties, and unless restricted by law, the whole case is therein open for re-hearing, both on questions of fact and law. And the judgment of the appellate court must, therefore, reflect its conscious application of mind and record findings supported by reasons, on all the issues arising along with the contentions put forth, and pressed by the parties for decision of the appellate court. And the task of an appellate court affirming the findings of the trial court is an easier one. And while agreeing with the view of the trial court, may not state the effect of evidence or reiterate the reason given by the trial court. The task of the first appellate court, being the last fact-finding court, ought to have discharged the statutory obligation cast on him. The pleadings and materials were brought on record before the first appellate court, and the first appellate court ought to have reappreciated the entire oral and documentary evidence independently. Having failed to do so, the interference is called for by this court in the second appeal. The pleading corroborated with the material on record would clearly establish that under the registered partition deed, which is not disputed by either of the parties, the suit property fell to the share of the grandfather of the defendants and not to the share of Abdul Majid Khan, alias Arifullah Khan, father of the plaintiff. And the courts below were not right in arriving at a conclusion that the suit schedule property was allotted to the share of Abdul Majid under Exhibit P1. And the substantial questions of law framed by this court is answered in favor of the plaintiff. And this court passed the following note. The regular second appeal is hereby allowed. The judgment and decree of the courts below are hereby set aside. suit of the plaintiff is hereby dismissed.
Much obliged, my lords. As my humble apologies, my lords could not be present there.
Yes. Your colleagues are here.
Grateful, my lords.
In light of the disposal of the second appeal, pending consideration of pending consideration of any interlocutory application would not arise. If any, pending consideration of any application would not arise. Yes. Yes, Mr. Alva. Mother deed. Have you produced mother deed?
Mother deed of
D15 they have produced.
they have
ಅದರಲ್ಲಿ 40/12 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
yeah 41 well is the you personally find it in 16.
That is your sale deed.
Same we do exhibit 37. E16.
That is what is difference in the exhibit D15 and exhibit 7 and future property.
E15 and the certificate property granted.
One ನಿಮಿಷ. There are three. ಈಗ there are three documents. Main documents are exhibit D15.
Main document is exhibit P7.
That is your
and
sale.
D7. That is my sale. P7 is my sale. D7 is their dispute.
That is not in dispute. First part, one portion. So we will not look at it.
What dispute?
One nimisha. Let us know whether we have understood this. You must have understood your matter, but
Yes.
we have understood all anta tilkolana. Exhibit D15 is the mother deed which they have produced.
They have
Alva, your vendor's title. Exhibit P7 is your sale deed. So this matter revolves around exhibit D17 and D15 and exhibit P7.
No, it revolves around exhibit P7, exhibit P7 and D7.
What is P7? No, that
P7 is my sale.
are the P7 and exhibit D15.
The total extent of the land is 11 acres. Total is survey number line, survey number line, the total extent is 11 acres 31 gutas. ಈಗ ಸರ್ವೆ ನಂಬರ್ 14 ಅಲ್ಲಿ altogether 12 divisions, subdivisions. Survey number 14.
Yes.
This defendant, this plaintiff had purchased altogether 11 acres 31 gutas as per this sale deed.
Which sale deed?
As per exhibit P7 sale deed.
This is P7. Yes. Where does it mention? Which is the survey number? Which is the Hissa number in this?
ಇಲ್ಲಿ P7 ನಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ನಮಗೆ Hissa number ತೋರಿಸ್ಬಿಡಿ. Where is it?
page 3 you are also will find it. Page 3. ಜಮೀನು ಶುದ್ಧ ಕ್ರಯಪತ್ರ ಅದಾಗಿ ಯಲಮಂಗಲದ ತಾಲೂಕು ದಾಸನಪುರದ ಹೋಬಳಿ ಮೈಯಂಡಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ನಮ್ಮ ಇಬ್ಬರ ಹೆಸರಿದ್ದು ಅಟೆ ಇದ್ದು ನಮ್ಮ ವ್ಯಾಪ್ತಿಯಾಗಿ ಕ್ರಯಕ್ಕೆ ಪಡೆದು ಅಲ್ಲಿ ನಮ್ಮ ಅಧೀನಾನುಭವದಲ್ಲಿರುವ ಯಲಮಂಗಲ ತಾಲೂಕು ದಾಸನಪುರ ಹೋಬಳಿ ಮೈಯಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40/1 ನಂಬರ್ ಪುಷ್ಟಿ 3 ಎಕರೆ 18 ಗುಂಟೆ ಆಕಾರ ₹2 20 ಪೈಸೆ ಉಳ್ಳ ಜಮೀನು ಅದು ಮುಂದಾಯ್ತು.
ಆಯ್ತು.
Then ಇಟೋ ಗ್ರಾಮದ ಹೃದಯದಿಂದ 21/7/1958ರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ನಂಬರ್
ಆಯ್ತು, ಅದು ಆಯ್ತು. ಈಗ
ಪ್ರಕಾರವಾಗಿ 40 ಸಬ್ 2ನೇ ನಂಬರ್
ಹಾ.
ಪುಷ್ಟಿ 23
ಹಾ
ಗುಂಟೆಗೆ ಆಕಾರದ ಕುಲ ಜಮೀನನ್ನು then next third one is ವಿಸಿ ಅಭಿಪ್ರಾಯದಿಂದ 16/11/57 ಗುರುಸ್ತಯ್ಯ ಕರೆಗೂ ನನ್ನ ಮೈನರ್ ಮಕ್ಕಳಿಗೂ ಸಹ ಕೃಷಿತತ್ವ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ಸೊ ಬುಕ್ ನಂಬರ್ ವಾಲ್ಯೂಮ್ ಸೊ ಪುಟಗಳಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಆಗಿರುವ ಐಟಮ್ ಸೊತ್ತು ಒಂದು ಇಟೋ ತಾಲೂಕು ಇಟೋ ಹೋಬಳಿ ಅಯ್ಯಸರಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40/3 40/1 ಆಯ್ತು 40/2 ಆಯ್ತು 40/3 ಹೇಳ್ತಾರೆ
ಆಯ್ತು.
21 ಗುಂಟೆ ಆಕಾರ ಜಮೀನು ನೆಕ್ಸ್ಟ್ ಹೇಳ್ತಾರೆ ಐಟಮ್ ಮತ್ತು ಇದೇ ಇಟೋ ತಾಲೂಕು ಇಟೋ ಹೋಬಳಿ ಅಯ್ಯಸರಣಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40ನೇ ನಂಬರ್ ಸಬ್ 4ನೇ ನಂಬರ್ 24 ಗುಂಟೆ
ಆಯ್ತು.
ಅದಾಯ್ತು. ಅನಂತರ ಇಟೋ ತಾಲೂಕು ಇಟೋ ಹೋಬಳಿ ಬೈಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40ನೇ ನಂಬರ್ ಸಬ್ 5ನೇ ನಂಬರ್ ಪುಷ್ಟಿ 5 ಗುಂಟೆಗೆ ಆಕಾರ
ಆಯ್ತು ಆಯ್ತು.
40/5ರಲ್ಲಿ 5 ಗುಂಟೆ.
ಆಮೇಲೆ 6.
ಅನಂತರ ಸರ್ವೆ ನಂಬರ್ ನೆಕ್ಸ್ಟ್ ಇಂದು 40ನೇ ನಂಬರ್ ಸಬ್ 6ನೇ ನಂಬರ್ ಪುಷ್ಟಿ 5 ಗುಂಟೆಗೆ ಆಕಾರ.
ಆಮೇಲೆ 7.
ಅದು 7 ಸಬ್ 7
7 ಸಿಕ್ತು ನಿಮ್ಗೆ. 8 ಆಮೇಲೆ
ನೆಕ್ಸ್ಟ್ ಸಬ್ 8ನೇ ನಂಬರ್ ಗುರುತಿದ್ದ ನನ್ನ ಮೈನಸ್ ಮಕ್ಕಳಿಗೂ
ಆಮೇಲೆ 9
ಆಮೇಲೆ 5
ಆಮೇಲೆ 9
9ರಲ್ಲಿ ಬಂದಿದೆ ಸಬ್ 9ರದ್ದು ಅದು 5 ಗುಂಟೆ ಬಂದಿದೆ. ಅನಂತರ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬರ್ತದೆ
11
40/10ರಲ್ಲಿ 38 ಗುಂಟೆ ಫಸ್ಟ್ ಲೈನ್.
ಹೌದು.
ಅನಂತರ ಒಂದು 4 5
ಆಮೇಲೆ 11
40/11ರಲ್ಲಿ 39 ಗುಂಟೆ.
ಹೌದು. ಇದೆಲ್ಲ ಕೂಡ ನಿಮ್ಗೆ 3 ಎಕರೆ 30 ಗುಂಟೆ.
ನಂತರ ಬಂದಿದೆ ಇಟೋ ತಾಲೂಕು ಹೋಗಿ ನಂತರ ಬರ್ತದೆ
ಏನ್ ಬರ್ತದೆ
ನಂತರ 21 ಮತ್ತು ಇಟೋ ತಾಲೂಕು ಇಟೋ ಹೋಬಳಿ ಬೈಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಪಟೇಲ್ ಸಿಂಗಾಪುರದಿಂದ
ಒಂದ್ ನಿಮಿಷ
ಗಂಗಮ್ಮ
ಮತ್ತು
ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಹೇಳಿ.
ಈಗ ಇಷ್ಟು ಐಟಮ್ ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಉತ್ತಮರಿಗೆ ಕೆಳದ ಮೂಲಕ ಬೈಂಡಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 40ನೇ ನಂಬರ್ ಪುಷ್ಟಿ 3 ಎಕರೆ 30 ಗುಂಟೆ ಆಕಾರ 4 ರೂಪಾಯಿಗಳ ಜಮೀನು ಒಂದು 16/6/54ರಲ್ಲಿ ನಂಬರ್ ಆಗಿರುವ ಒಂದು ಹೇಳ್ತಾರೆ. ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ D50 ಅದನ್ನು ಅವರು ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ D50 ಅಂತ ಹೇಳ್ತಾ ಇರುವಂತ. ಇದು ಒಂದು ಐಟಮ್ಗೆ ಮಾತ್ರ ಅದು ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ D50 ಇದೆ. ಬಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಬಿಕಾಸ್ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಇದೆ ಎವಿಡೆನ್ಸ್ ಇದೆ. ಇಲ್ಲಿ ಒಟ್ಟು ಕೆಳಗೆ ಹೇಳ್ತಾರೆ
3 acres 30
3 lines kindly refer to last 3 lines. ಪುಟಗಳಲ್ಲಿ ನಮೂದಾಗಿ ರಿಜಿಸ್ಟರ್ ಆಗಿರುವ ಐಟಮ್ ಜಮೀನು ಒಂದು ಜುಮ್ಲಾ 12 ಐಟಮ್ ಸೊತ್ತು ಒಂದೇ ಕಡೆ ಇರುವುದರಿಂದ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಅದೇ ಪೇಜ್ ಲಾಸ್ಟ್ 3 lines ಲಾಸ್ಟ್ 2 lines
ಸೇಮ್ ಪೇಜ್.
It starts with the first line. Iಟೋ ಹೋಬಳಿ ಬೈಂಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40ನೇ ನಂಬರ್ ಸಬ್ 10ನೇ. ಈಗ
ಅದೇ ಇದು ಓದಿದ್ವಲ್ಲ.
ಅದೇ ಲಾಸ್ಟ್ 2 lines. ಲಾಸ್ಟ್ 2 lines. ಜುಮ್ಲಾ ಇವು 12 ಐಟಮ್ ಇಲ್ಲಾಂದ್ರೆ ಟೋಟಲ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಐಟಮ್ 12 ಐಟಮ್ ಸೊತ್ತು ಒಂದೇ ಕಡೆ ಇರುವುದರಿಂದ ಒಟ್ಟು ಚಕ್ಕು ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಬೆಟ್ಟಹಳ್ಳಿಗೂ ಕಡಬಗೆರೆಗೂ ಹೋಗುವ ರಸ್ತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ಅರ್ಕಾವತಿ ನದಿ, ಉತ್ತರಕ್ಕೆ ಚಿಕ್ಕದೊರೆ, ದಕ್ಷಿಣಕ್ಕೆ ಶಿವರುದ್ರಯ್ಯನವರ ಜಮೀನು.
ಏನು ಈಸ್ಟಿಗೇನು?
ಈಸ್ಟಿಗೆ ಪೂರ್ವಕ್ಕೆ ಬೆಟ್ಟಹಳ್ಳಿಗೂ ಕಡಬಗೆರೆಗೂ ಹೋಗುವ ರಸ್ತೆ.
ಇದು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು ಇದರದ್ದು?
ಇದರಲ್ಲಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ 11 ಎಕರೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿರುವಂತದ್ದು 11 ಎಕರೆ 1 ಗುಂಟೆ. ಅದು 12 ಎಕರೆಯಿಂದ 12.5 ಎಕರೆ ಇದೆ. ಅದು 12.5 ಎಕರೆಯಿಂದ ಜಾಸ್ತಿ.
ಆಮೇಲೆ ಒರಿಜಿನಲ್ ಮದರ್ ಡೀಡ್ ಎಕ್ಸಿಬಿಟ್ D15 ಇರೋದು
D15 ಇದು ಒಂದು ಐಟಮ್ಗೆ ಮಾತ್ರ. ದೀಸ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅದನ್ನ ಇವರು ಬೇರೆ ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
And in terms of the other documents,
So you have, according to you, you have purchased 11 acres.
I have purchased 11 acres. The lordship will find the mother deed of survey number 40/1 is exhibited D9.
1 second. No, nim prakara, you are the plaintiff.
Please.
You are saying that as per exhibit P7,
P7.
you have purchased
11 acres, 31 quotas.
11 acres. 11 acres,
31 quotas. My mother deeds have been produced by the government itself. They have produced the documents.
Mother deed is?
In respect of 40/1, it is exhibited D9. Exhibit D9 for 40/1. Exhibit D10 for 40/2. Exhibit D11 for 40/3. Exhibit D12 for 40/4. Exhibit D13 for 40/5. ಅದು ಇನ್ನೊಂದು 4 ಐಟಮ್ಸ್ ಸೇರ್ಕೊಡುತ್ತೆ ಅದರಲ್ಲಿ. D13 ನಲ್ಲಿ 40/5, 6, 7, 8, 9, 10 ಅಲ್ಲಿ ತನಕದ್ದು D13 ನಲ್ಲಿ ಕವರ್ ಆಗಿದೆ. ಆಮೇಲೆ ಸರ್ವೆ ನಂಬರ್ 40/11 ಗೆ D14. 40/11 ಗೆ 40/11 ಗೆ D14. ನಮ್ಮ ಮದರ್ ಡೀಡ್ಸ್ ಎಲ್ಲ ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ನನ್ನ ಕೆಲಸ ಕಮ್ಮಿ ಮಾಡಿದ್ದಾರೆ. Then D15 is for survey number 40.
40/12.
Actually it is 40/12. ಅಲ್ಲಿ document ಅಲ್ಲಿ 40 ಅಂತ ಆಗಿದೆ.
ಅಲ್ಲ, ನಿಮ್ದು ಇವೆಲ್ಲ ಹಿಸ್ಸಾ ಆದಾಗ
ಹಿಸ್ಸಾ 56 ಅಲ್ಲಿ ಆಗಿರುವಂತದ್ದು. ಸೊ ಇದು 54ರ ಡಾಕ್ಯುಮೆಂಟ್, ಹಾಗಾಗಿ ಹಿಸ್ಸಾ ನಂಬರ್ ತೋರಿಸಿಲ್ಲ. This document D15 is of 1954. 54. ಹಿಸ್ಸಾ ಆಗಿರುವಂತದ್ದು 1956 ಅಲ್ಲಿ. You not still find it at exhibit D16.
year 1956.
ಹೌದು, 18/1/56 ಅಲ್ಲಿ ಹಿಸ್ಸಾ ಆಗಿರುವಂತದ್ದು.
D16
D16 ಅಲ್ಲಿ ಹೇಳುತ್ತೆ.
D16 ಅಲ್ಲಿ ತೋರಿಸಿ. Where is that 56 ನಲ್ಲಿ ಆಗಿದ್ದಕ್ಕೆ?
18/1/56ರಲ್ಲಿ ಹಿಸ್ಸೆಗಳು ಅಳತೆಯಾಗಿ 1 ರಿಂದ 12 ಹಿಸ್ಸೆಗಳು ಈ ಕೆಳಗಂಡಂತೆ ಗೊತ್ತಾಗುತ್ತೆ ಹೇಳ್ತಾರೆ. ಏಕಲೈನ್ ಪ್ರಮಾಣ ಈ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಇದ್ದಾರೆ, ಅದರಲ್ಲಿ ಸೆವೆಂತ್ ಲೈನ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಕಾರ್ಯಕ್ರಮಕ್ಕೆ 56 ಹಿಸ್ಸೆಗಳು ಅಳತೆಯಾಗಿ 1 ರಿಂದ 12.
ಅಲ್ಲಿ ಹಿಸ್ಸಾ ನಂಬರ್ 12 ಗೆ whose name is entered?
ಹಿಸ್ಸಾ ನಂಬರ್ 12 ಗೆ ಭೂತಾನ ಮತ್ತು ಮೈಸೂರು DPI ಅಂತ DPI ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಹಿಸ್ಸಾ ನಂಬರ್ 12 ಗೆ
So already there is there in their favor.
Lordship can consider. You take your lordship to the evidence. ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ನಾವು ಜಾಸ್ತಿ ಕೊಡ್ತೀವಿ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು, ಆಮೇಲೆ ಕೊಟ್ಟದ್ದು ಒಂದೇ. This evidence has come with the
ಏನು ಜಾಸ್ತಿ
ಜಾಸ್ತಿ ಜಾಗ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಕೊನೆಗೆ ಕೊಟ್ಟದ್ದು ಒಂದೇ ಎಕರೆ ಆಸ್ ಪರ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ D7. ಉದಾಹರಣೆಯಲ್ಲಿ ನಾವು ಜಾಸ್ತಿ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು, ಬಟ್ ಕೊಟ್ಟಿರೋದು ಕೇವಲ ಒಂದೇ ಎಕರೆ.
ಯಾರಿಗೆ?
ಭೂಗಾಂಧದ ಸರ್ಕಾರಕ್ಕೆ ಕೊಟ್ಟಿರುವಂತದ್ದು, ಸ್ಕೂಲ್ಗೆ ಅಂತ ಕೊಟ್ಟಿರುವಂತದ್ದು ಒಂದೇ ಎಕರೆ. ಸ್ಕೂಲ್ ಅಲ್ಲಿರೋದಲ್ಲ, ಸ್ಕೂಲ್ ಅಲ್ಲಿಂದ 1 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿದೆ. From this fact, I have gone to this spot and verified ಎಲ್ಲಿ ಸ್ಕೂಲ್ ಇದೆ ಅಂತ. ಅದು ಊರ ಒಳಗಡೆ ಬರ್ತದೆ, 1 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ, 1.5 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ. ಇದು ರಿವರ್ ಸೈಡ್ ಬಂದು ರಿವರ್ ಸೈಡ್ ಇರುವಂತ ಜಮೀನು.
ಸೊ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಖಂಡಿತ ಅಂತ ಎಕ್ಸ್ಪೆಕ್ಟ್ T7.
What is D7?
T7 is the 50 days. ಗಿಫ್ಟ್ ಮಾಡುವಾಗ 40/1 ಮಾತ್ರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, 40/12 ಮಾಡೋದಿಲ್ಲ.
ಇದು ಗಿಫ್ಟ್ ಡೀಡ್ ಯಾವಾಗ?
ಗಿಫ್ಟ್ ಡೀಡ್ ಡೇಟ್
90? ಅವಾಗ ಹಿಸ್ಸೆ ಆಗಿತ್ತಾ? ನಿಮ್ ಪ್ರಕಾರ 56 ನಲ್ಲಿ ಹಿಸ್ಸೆ ಆಗಿದೆ.
10/4/1956 ಅವಾಗ ಹಿಸ್ಸೆ ಆಗಿತ್ತು.
10/4/1956.
ಹಿಸ್ಸೆ ಆಗಿರುವಂತದ್ದು as per the seen from exhibit D16 it was on 18/1/1950. D16 ನಲ್ಲಿ
ಅದೇ is on 18/1.
18/1/1950 ಹಿಸ್ಸೆ ಆಗಿದೆ. ಇವರಿಗೆ ಭೂದಾನದಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತದ್ದು 10/4/1956 ಗೆ D7 ಮನೆ.
Exhibit
D7 ನಲ್ಲಿ D7 dated 10/4/1956.
40/1 ಕೊಟ್ಟಿದ್ದೀರಾ?
40/1 ಕೊಟ್ಟು 40/12 ಕೊಟ್ಟಿಲ್ಲ, 40/1 ಮಾತ್ರ ಕೊಟ್ಟಿಲ್ಲ.
40/12
40/1 ಬಗ್ಗೆ ನಾವೇನು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
you have to show that 40/12 is being allotted to you and you mean you have purchased.
I have purchased
ಅಂತ ತೋರಿಸಬೇಕು ಫಸ್ಟ್.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನನ್ನ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ 5 of the sub division number ಅನ್ನು ಹಾಕಲಿಲ್ಲ. Because
when all the documents mother deed and all everything say that these are these Hissa numbers and these are the properties which you have to be given to you.
Yes.
Why was there no mention of 40/12?
Because in my mother deed it was mentioned as 40 only. 40/12 ಅಂತ ಮೆನ್ಷನ್ ಆಗಿರಲಿಲ್ಲ.
40 ಅಂತ ತೋರಿಸಲಿಕ್ಕೆ where did you say that it is 40?
D50. D50 ನಲ್ಲಿ 40/12 40 ಅಂತ ಹೇಳಿದೆ.
ಅದು 40 measuring 3 acres 30 guntals.
ನಾನು the property in the question before.
Where is that in your exhibit? P7 ತೋರಿಸಿ ಇನ್ನೊಂದ್ಸಲ.
P7 ನಲ್ಲಿ
ಇನ್ನೊಂದ್ಸಲ ತೋರಿಸಿ. P7 3 ಎಕರೆ ಎಲ್ಲಿದೆ? ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು? 11 ಆದ್ಮೇಲೆ ಓದಿ. ಅಂದ್ರೆ 40 ನಂಬರ್ ಸಬ್ ನಂಬರ್ 11 ಆದ್ಮೇಲೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್
ಕ್ರಯದ ಮೂಲಕ ಬೈಂಡಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 40ನೇ ನಂಬರ್ ಕುಷ್ಟಿ 3 ಎಕರೆ 30 ಗುಂಟೆ.
ಇದೆಲ್ಲ ಕೂಡ ಎಷ್ಟಾಗತ್ತೆ?
ಎಲ್ಲ ಸೇರಿದ್ರೆ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು 11 ಎಕರೆ 31 ಗುಂಟೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ.
40/1 ನೀವು ತೋರಿಸಿದ್ರೆ ಅದರಲ್ಲಿ ಎಷ್ಟು
40/1 ನಲ್ಲಿ 1 ಎಕರೆ 15 ಗುಂಟೆ.
ಒಂದು ನಿಮಿಷ. 40/1 as per exhibit P7 ಎಷ್ಟು?
1 ಎಕರೆ 15 ಗುಂಟೆ.
1 ಎಕರೆ 15 ಗುಂಟೆ.
18 40/2 ನಲ್ಲಿ 23 ಗುಂಟೆ. 40/3 ನಲ್ಲಿ 23 ಗುಂಟೆ. 40/4 ನಲ್ಲಿ 24 ಗುಂಟೆ. 40/5 ನಲ್ಲಿ 5 ಗುಂಟೆ.
ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ. 1 acre 18 ಗುಂಟಾಸ್. ಹೇಳಿ 40 ಬಾರ್ 5 40 ಬಾರ್ 5 ಅಲ್ಲಿ
40/5 ನಲ್ಲಿ 5 ಗುಂಟೆ.
40 ಬಾರ್ 6 ನಿಮ್ಗೆ ಸಿಗ್ಲಿಲ್ಲ.
40/7 ನಲ್ಲಿ 5 ಗುಂಟೆ. 40/8 ನಲ್ಲಿ 5 ಗುಂಟೆ. 40/9 ನಲ್ಲಿ 5 ಗುಂಟೆ. 40/10 ನಲ್ಲಿ 38 ಗುಂಟೆ.
40/10
38 acres. 40/11 ನಲ್ಲಿ 2 acres 39 ಗುಂಟೆ.
3 acres
2 acres 39 2 ಎಕರೆ 39.
ಆಮೇಲೆ
ಆನಂತರ 40/12 ಅಂತ ಬಂದಿಲ್ಲ, 40 ಇದು ಬಂದಿದೆ 3 acres 30 ಗುಂಟೆ.
40 ಎಷ್ಟು
3 acres 30 ಗುಂಟೆ.
1 acre 18 ಗುಂಟಾಸ್ 23 ಗುಂಟಾಸ್ plus 23 ಗುಂಟಾಸ್ ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಬರುತ್ತೆ 1 acre ಒಂದು ಕಡೆ ಬಂತು 1 acre 18 ಗುಂಟಾಸ್ 23 ಗುಂಟಾಸ್ ಆಡ್ ಮಾಡಿ plus 23 ಬರುತ್ತೆ 1.18 0.23 0.23 0.23 0.22 0.5 0.5 0.5 ಇಲ್ಲ 0.5 maximum. ಆಮೇಲೆ 38 ಕೊಡ್ಬೇಕು 0.38 ಆಮೇಲೆ 2.38 39 ಆಮೇಲೆ 3.39 30
9.95.
9.95
7.5. 7.80. 11.15.
Yes, how much you purchased?
I had purchased 7 acres 15 ಗುಂಟಾಸ್.
Yes.
7 acres ಇದರ ಪ್ರಕಾರ 31 ಗುಂಟೆ ಅಂತ ಹೇಳಿದ್ರೆ ಬೆಟರ್.
ಅಂದ್ರೆ 9.95 ಗುಂಟಾಸ್ ಅಂತ ಬರುತ್ತೆ. If you add it, it becomes 11.15 ಗುಂಟಾಸ್.
ಅಷ್ಟು ಏನು ಪರ್ಚೇಸ್ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ 11 ಅಂತ ಹೇಳ್ತಾರೆ
11.15
11 acres 15 gunters, but this is the land we have purchased. Now I am permitted to take the lordship to their defense in the written statement. Paragraph 7 and 8 extend that.
What did the trial court do and what did the first appellate court do?
Trial court
dismissed.
It is my demand. Commissioner appointed. Commissioner submitted it to the examiner. Additional document for this is when the trial is there. This is the truth. What thing that I have not produced my mother deeds. Despite the fact that this D15 is the mother, all these documents are produced by the defendant themselves. My mother deeds have been produced by the defendant themselves.
Yes, understood.
D9 to D15. They are my mother deeds. Exhibit D9 to D15. The defendant themselves are produced. Once it is based on record, whether I produce or the other side produce, it makes no difference.
Now, what, according to you, this mother deed and the mother deed at exhibit D15 together was around 11 acres 15 guntals, and you have purchased all the properties as per exhibit P7. That is your
all these documents are purchased. All these properties are purchased. You have to pay. P7.
Paper book.
Now,
paper book.
paper book illa.
I thought DW. Paper book, in fact, it is a burden. ಅಲ್ಲ ಅಂದ್ರೆ ಸಿ ಪೇಪರ್ ಬುಕ್ ನಾವು ಪೇಪರ್ ಬುಕ್ ನೋಡೋದೇ ಇಲ್ಲ. ವಿ ಆಲ್ವೇಸ್ ಲುಕ್ ಇನ್ ಟು ದ ರೆಕಾರ್ಡ್ಸ್. ಪೇಪರ್ ಕನ್ವೀನಿಯನ್ಸ್ ಗೆ ಅಷ್ಟೇ ಟೈಪೇ ಕರೆಕ್ಟ್.
Again, always better to cross verify with the
Records.
records.
Evidence of yardo?
First, I will take a look to the return statement of these
That is.
defendants. Return statement.
Mr. Your name is Prakash, huh? Prakash. What is your name? Rajendra. Now you have to substantiate in light of this, Exhibit P7, though it is not mentioned as 40/12, but the hissas have been taken place only in the year 1956. As on the date when he had purchased the property, his vendor, Exhibit D15, it was in the year 54. So there was no hissa to that. Hissa irlilla. And that is how he purchased the property. When did you purchase?
We have purchased in 1970. And the documentally, I was the 40/12 the mention angle. There is one defect on which the government is playing a role.
That you have to see.
Kindly.
Here, body, it also mentioned.
One ನಿಮಿಷ ನೋಡೋಣ ಆಯ್ತಾ? Yes, you.
Take a lot of the written statement of the defendant. Paras, I won't give you a lot of.
When you written statement, government the written statement ನೋಡಿದ್ರೆ
It's a specific reason because you will not be getting it here. As held by the apex court in Kalyan Chinchaman case. The pleadings is the basic foundation on which the entire suit revolves. Issues will be framed based on the pleadings. The court did not look into the other matters in respect of which the issues have not been framed. Therefore, the court has to confine and restrict itself only in respect of the issue. The basis for this issue is the pleadings. Now, kindly turn to paras 17. It is submitted that the suit schedule land is in the possession of the aforesaid school right from 1958. That is for 28 years continuously, peacefully, without obstruction from any corner, and even otherwise, the defendant has perfected his title by advance donation. Advance donation against the private party. Unfortunately,
Government of Kerala, a judgment ಇದೆಯಲ್ಲ. They have no law. They have given up their right. Now they have given up their right.
Then the next para, it is submitted that
It is submitted that second defendant acquired survey number 40.
title of gift from late CH-27 of maintainability in the year 1956. And ಇದು ಈಗ 1956 is ಹೇಳ್ತಾ ಇರೋದು exhibit D7 gifted in the ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು 40/1.
There is no dispute.
So we will not look into that. 40/12 ಅಷ್ಟೇ.
And ಹೇಳ್ತಾರೆ survey number 40/12 under the endorsement number A3 case number 69/5657. Now where it is? It has not been put. 40/12 ಅವರಿಗೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Where they put endorsement is? Why that document has not been produced? That is one aspect. And even this honorable court while remanding, there was a specific reference to the remand order.
Even if you give up your claim, but your first pleading is that you have perfected your title by way of adverse possession. So what it means, you are admitting the title of the plaintiff. Now you must have given up. Now you, because of your counsel or because of your understanding that you do have no case for adverse possession, right? Now,
Exact observation of the first appellate court. The first appellate court says that they have taken the plea of adverse possession. Thereby they have admitted my title.
now you want to forgive the adverse possession, even if you say you want to forego, we cannot forego you because these are the pleadings of yours. Endorsement ಅಂತಾರೆ.
Regarding the unit P60, very clear, they have mentioned along with the 12 others, they are going to allot this property to the primary school. Unit 60 itself is.
So after this allotment, they have purchased this property.
And in 56 itself, it has been mentioned. That the unit P60 is very
Yes, we
clear.
will look. ಅಲ್ಲ ಒಂದು ಸ್ಲೈಟ್ ಡಿಫ್ರೆನ್ಸ್ ಏನಂದ್ರೆ
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸರ್ಕಾರದವರು 1 ಎಕರೆ ಬಗ್ಗೆ ನಮ್ದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ಈ 1 ಎಕರೆ ಇಟ್ಕೊಂಡು ಇನ್ನೊಂದು ನಮ್ಮ ಜಮೀನನ್ನು ಒಳಗಾಚೆಗೆ ಹೋಗ್ತಾ ಇರೋದು ದಟ್ ಈಸ್ ದ ಪಾಯಿಂಟ್.
Now whether a school is constructed,
School is constructed at a distant place.
it is not constructed in 40 bar, ಅಲ್ಲ in 40 bar 12 construction ಆಗಲಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲ.
What is the
distance of 1.5 kilometers?
What is the decree by the first appellate court now?
First appellate court ಈಗ ನಾನು ಫೈಲ್ ಮಾಡಿದ ಡಿಕ್ಲರೇಷನ್ ಕೂಡ ಹಾಕಿದ್ದಾರೆ, ವಜಾ ಮಾಡಿದ್ದಾರೆ, ನಾನು ರೈಟ್ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ.
First appellate
court has the decree
holding that you are the absolute owner. Then no possession because you have
already in possession. ಅದು ರಿವರ್ ಸೈಡ್ ಗೆ ಬರ್ತದೆ, ಅಲ್ಲಿ ಅರ್ಕಾವತಿ ರಿವರ್ ಬರ್ತದೆ, ಅದರ ಸೈಡ್ ಗೆ ಬರ್ತದೆ. ಇದು ಕೃಷಿ.
Any sketch produced by either of the parties?
Sketch has been produced. You are not supposed to. The commissioner has been appointed for that only. You are not information of this normal court in the earlier round of litigation. RSA 484.
ಇದರಲ್ಲಿ ಎಲ್ಲಿದೆ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ?
ಅದು ನಾನು ಮೆಮೋದ ಜೊತೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇದೆ. ಸೆಕೆಂಡ್ ಅಪೀಲ್ ರಿಮಾಂಡ್ ಆಯ್ತು.
I had drawn your logical attention to that. The development in the record.
The dispute is in a very narrow compass now. 1956, there is a Issa, Kodi. They purchased in the year 1970. You have, in the year 1958, you have got a document. Yes.
Operation. This court has considered this aspect with the case conduct act. Para 6 के kind of different.
One निमिष para 12 होगी. Para 2.
The plaintiff claimed that two land bearing number 40/12 and maintainability has been purchased by plaintiff of property. One group the under the registered state dated 2/3/1970. Since then, the plaintiff is in peaceful possession and enjoyment of the property. He has further contended that a group of boys belonging to government primary school trying to enter into the school land and caused damage to the property. In this connection, the plaintiff approached the competent officers of the education department and he came to know that the defendants were given property survey number 40/1 and an equity executed by on 10/4/19. Even though the property gifted in survey number 40/1, the defendants are claiming 40/12, which belongs to the plaintiff, and he is the absolute owner of the property, and they are trying to interfere with the possession and enjoyment of the plaintiff. The plaintiff got issued notice as required to section 80 CPC, for which no reply has been given.
I do not come to para 6.
Before going into the title of the respective parties, The courts below ought to have appointed a commissioner to locate the properties because of the confusion confirmed. Therefore, the matter has to be remitted back to the trial court to appoint a survey commissioner to locate the properties, survey number 40/1 and 40/12, and draw a separate scale pointing out the locations and these locations of these properties. After receiving the scale, the trial court shall also call for the government records to the very same surveyor and find out to whom the lands belong originally and what was the right of Murtidappa to convey the right to the plaintiff. The trial court must also find out whether a mere endorsement can confer title in respect of the property. Lord Mechanical in the letter statement para 8, they say there is a endorsement. Some court in the earlier point of time had considered this. 7, para 7. To consider these aspects, the matter is remitted to the trial court, setting aside the judgment and decree of the courts below. The parties are directed to appear before the court on 15/7/1998. The second appeal is accordingly allowed. What should we kindly consider? In the first round, I had succeeded in the trial court. That judgment was reversed by the first appellate court. Again, that I had come up before this honorable. In the second round, the trial court had went against me, but the first appellate court had supported. Now, my lord, in furtherance of this, the assistant director of land records was appointed as the division. ADLR was appointed as the court commissioner. The court commissioner had visited the spot, surveyed the properties, and prepared the scale. Kindly turn to exhibit P90. Next people.
What is exhibit D19?
D19 is the sketch.
B19.
B19, B series.
B19 is not.
B19 mother. B20 is the same. Well, those ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ ಪ್ರದೇಶವನ್ನು ಪ್ರಾಥಮಿಕವಾಗಿ ಏಳರಿಗೆ ದಾರದ ಮೂಲಕ ದಿನಾಂಕ 14/56 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದರ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ, ಸರ್ವೆ ನಂಬರ್ 40/3. ಅದನ್ನೆಲ್ಲ ಹೇಳ್ತಾರೆ ಯಾವುದು ಪ್ರಾಪರ್ಟಿ ಯಾರ್ಯಾರು ಅದನ್ನು ತೋರಿಸ್ಕೊಡ್ತಾರೆ ಯಾವ ಯಾವ.
Who has conducted this, Mahasar?
It was conducted after the remand order.
Commissioner.
The matter was remanded.
Commissioner
The
has.
commissioner had drawn this measure.
Exhibit P19.
P19 and P20 is the sketch.
Mahasar by Commissioner.
ADLR, Assistant Director of Land Records.
ADLR after remand.
After remand. And in the sketch you will also find all these divisions are been shown. ಎರಡು ಮೂರು ನಾಲ್ಕು ಐದು ಆರು ಏಳು ಎಂಟು
Really, one day is there. Where are you reading? 1, 2, 3?
sketch ನಲ್ಲಿ 20 P20 sketch.
ಅಲ್ಲ P20 ನಲ್ಲಿ 1 ಮತ್ತು 2 ಅಷ್ಟೇ ತೋರಿಸಿದ್ದಾರೆ. 1 ಮತ್ತು 12.
ಈಗ 1 ಅವ್ರದ್ದು 12 ನಮ್ದು.
12 ನಿಮ್ದಂತ ಏನ್ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ ಮಾಜರ್ ನಲ್ಲಿ? When was this?
The title deeds. The ADLR, who is an officer of the government, is their officer.
No, where do you find it? ಭೂ ದಾಖಲೆ ಸಹಾಯಕ. ಸೊ ಬೆಂಗಳೂರು ವಿಭಾಗ ಬೆಂಗಳೂರು ಇವರನ್ನು ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅನ್ನು ನೇಮಿಸಿ ಮಾಡಿ ಅಳತೆ ಮಾಡಲು ಸೂಚನೆ. ಬೆಳಗ್ಗೆ ಮಾಜರ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಲ್ಲ, ಮೇಜರ್ ಅಂತ ಆ ಬಣ್ಣದ ನಾವು ಈಗ ಬನ್ನಿ ಮ್ಯಾಪ್ ನಲ್ಲಿ
ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ ಪ್ರದೇಶವು ವಾದಿಗಳು ಸಭೆಯ 40/12 ಪ್ರಯತ್ನದ ದಿನಾಂಕ 1/70 ಪ್ರಯತ್ನ ಪಡೆದು ಅನುಭವದಲ್ಲಿರುವ ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 11 ಆಗಿತ್ತು. ಚಟ್ಟ ಮಧ್ಯದಲ್ಲಿ
2 ಎಕರೆ 11 ಯಾಕೆ ಆಯ್ತು ಈಗ?
ಅದು 3 ಎಕರೆ 30 ಗುಂಟೆ ಅಂತ ಅಲ್ಲಿ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಆಕ್ಚುಲಿ ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡಿದಾಗ ಜಾಗ ಅಷ್ಟು ಇರಲಿಲ್ಲ, ಜಾಗ ಇದು ಕಮ್ಮಿ ಆಯ್ತು. ಡಾಕ್ಯುಮೆಂಟಲ್ ಅಷ್ಟಿದ್ರು ಕೂಡ ಆಕ್ಚುಯಲ್ ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್ ಇನ್ನೂ ಕಮ್ಮಿ ಇತ್ತು. ಅದಕ್ಕಾಗಿ 2 ಎಕರೆ 11 ಗುಂಟೆ ಆಗಿರೋದು. So the last page ಈ ಬಣ್ಣದಲ್ಲಿ ತೋರಿಸಿರುವ ಪ್ರದೇಶವು ವಾದಿಗಳು ಸರ್ವೆ ನಂಬರ್ 40/12 ಪತ್ರ
ಅದೇ ಇದರಲ್ಲಿ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಅದೇ ಇದೆ ಅಲ್ಲ, ಬ್ಲೂ ಕಲರ್ ಮಾರ್ಕ್ ಮಾಡಿ ತೋರಿಸಿದ್ದಾರೆ. As per the document it is ಅಂತ ಹೇಳಿ you have been in possession ಅಂತ ಹೇಳ್ತಾರೆ.
The court commissioner has been examined as PW4 and all these documents have been marked as per exhibit P13 to P20.
As PW4
PW4
and Mazar and sketch is been marked as
P19 and P20.
Yes. What about the other documents? It's the same. The boundary shown. Boundary shown in boundary shown at exhibit D9 to D14. Wherein
ಅದಕ್ಕೆ ಬೇರೆ ಬೇರೆ ಬೌಂಡರೀಸ್ ಬರ್ತದೆ. If you not kindly turn to exhibit
northern side
P7 ನಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ನಮಗೆ ಸೇರುವ ಎಲ್ಲ ಜೊತೆಗೆ ಒಂದು ಬೌಂಡರಿ ಬರುತ್ತೆ.
Northern side ಗೆ it is shown as the land belonging to the school ಅಂತ ಹೇಳ್ತಾರೆ. Exhibit D9 to D14. All the documents which you place reliance now under the document mother deed which they have produced.
P7 ನಲ್ಲಿ full property boundary
ಆಯ್ತು ಅಲ್ಲ ಅದಲ್ಲ, the boundary shown in exhibit D9 to D14.
D9 to D14. D9 to D14 ನಲ್ಲಿ
the northern boundary is shown as land belonging to school. Boundary ಬನ್ನಿ. ಬಂದಿ ಪೂರ್ವಕ್ಕೆ in his possession, ಉತ್ತರಕ್ಕೆ ಸ್ಕೂಲಿಗೆ ಸೇರಿದ್ದ ಜಮೀನು,
ಅದಕ್ಕೆ ಸ್ಕೂಲ್ಗೆ ಸೇರಿದ ಜಮೀನು ಅಂತ ಇನ್ನೊಂದರಲ್ಲಿ D9 ನಲ್ಲಿ
ಆಮೇಲೆ D10 ಗೂ ಬನ್ನಿ. ಉತ್ತರಕ್ಕೆ ಅದು ಒಂದೇ ಲೈನ್ ತಾನೆ? ಇಟ್ ಆಲ್ ಲೈನ್ ಒನ್ ಲೈನ್ ಅಲ್ವಾ? ಉತ್ತರಕ್ಕೆ
ಕೂಲಿಗಾಗಿ ಭೂದಾನ ಮಾಡಿರುವ ನಮ್ಮ ಜಮೀನು ದಕ್ಷಿಣಕ್ಕೆ ನಂಜಪ್ಪನವರ ಮಕ್ಕಳ ಜಮೀನು
ಅಲ್ಲ, ಉತ್ತರಕ್ಕೆ ಅಲ್ಲ.
ಉತ್ತರಕ್ಕೆ ಭೂದಾನ ಮಾಡಿರುವ ಜಮೀನು ಅಂತ.
ಈಗ ಟು ಶೋ ದಿ ಲೊಕೇಶನ್ ಆಫ್ 40/1 and 12 ಎಲ್ಲಿದೆ ಅದು? You showed one document. They showed one document. Which was that? Bina Pina. D16 sketch alla. What is the document you showed? D?
Survey sketch in D7 to 12.
D18.
D18.
Who has produced this? The dependent. Leave. D18.
D18 ನಲ್ಲಿ ಸ್ಕೆಚ್
ಅದೇ ನಾರ್ತ್ ಗೆ ಸ್ಕೂಲ್ ಅಂತ ತೋರಿಸ್ಬಿಡ್ತಾರ.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಂದ್ರೆ
D18 ನಲ್ಲಿ D19 ನಲ್ಲಿ ಭೂದಾನ ಅಂತ ಹೇಳ್ತಾರೆ. In D19, pending to D19. Next out. ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಡಿವಿಷನ್ ಗೆ ಉದ್ರಯ್ಯ ಬೀನು ದೊಡ್ಡಯ್ಯ ದೊಡ್ಡ ಶಿವ ರುದ್ರ ಅವರ ಜಮೀನು ಅಂತ ಹೇಳ್ತಾರೆ. 12th ಗೆ ಭೂದಾನ ಮೈಸೂರು DPI ಅವರು ಅಂತ ಹೇಳ್ತಾರೆ. D1 ಗೆ ಅದನ್ನ ಹೇಳೋದಿಲ್ಲ. This is the confusion confounded in this matter. D1 ಅಂತ ಹೇಳಿದ್ರು ಬದಲು D12 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಆಯ್ತು, ಬಟ್ D12 is shown as not 12 on top. ಮೇಲಿದೆ.
ಹೌದು, D12 ಮೇಲಿದೆ
ಅಲ್ವಾ?
ಇಲ್ಲಿ D12 ಅಂತ ಹೇಳ್ತಾರೆ. But if you also kindly turn to exhibit D7, that clarifies.
Maybe you are entitled for declaration. Question is D1, 40/1, 40/2 all come below D12. Alva?
D12
north ಬರ್ತದೆ. On all the sale deeds of 40/1, 40/2, 40/11 tana, it is shown as north, the property of the school. North the property. Ella kade, all the sale deeds. How do you justify that?
ಅವರ ಗಿಫ್ಟ್ ಡೀಡ್ ಆಗಿರುವಂತದ್ದು.
ಅಲ್ಲ, ಗಿಫ್ಟ್ ಡೀಡ್ ನಲ್ಲಿ ಸ್ಕೂಲ್ ಇದೆಯಾ? ಇಲ್ಲ.
ಗಿಫ್ಟ್ ಡೀಡ್ ಅಲ್ಲಿ ಸ್ಕೂಲ್ ಇಲ್ಲ, ಉಳಿದ ಪ್ರಾಪರ್ಟಿ ಸ್ಕೂಲ್ ಇಲ್ಲ. ಸ್ಕೂಲ್ ಇರುವುದು another 1.5 kilometer ಡಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ. ಅವ್ರು ಏನ್ ಹೇಳುವಂತದ್ದು ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು ಬೆಳೆ ಬೆಳೆದು ಸ್ಕೂಲ್ಗೆ ಯೂಸ್ ಮಾಡ್ತಾರಂತೆ. ವೆರಿ ಸೇಮ್ ಕೇಸ್. ಭೂದಾನದಲ್ಲಿ ಜಮೀನು ತಗೊಂಡು ಅವರು ಯಾರ್ಯಾರಿಗೋ ಇದಕ್ಕೆ
ಇದಕ್ಕೆ ಏನು ಅಂತೀರಾ ಈಗ? See, all the documents show that there is to the north is the property of the school.
Is that been clarified to their donor himself? He has been examined. Their donor has been examined. What should be kindly to his evidence? Take a lordship to the deposition of DWT.
Exhibit?
Deposition of DWT.
DW2 who is he?
He is there with us.
Fitness.
Page 2, what's the fact?
Page 2 of
Page 2 of DW2, examination card.
the scooters of the year 54, 55, tail leads.
76 will start as
Ah.
48 years old. It need to apply ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. They have to apply at again by 1938. So ಅಲ್ಲಿಂದ trial could decrease, first grade could reverse, and again issue this
Demand.
Again went back to the trial court. Trial court reverse, first grade court decrease. Now the government is
ಬುದ್ಧಿ ಹೇಳಿ DW2.
ಅರ್ಧ ಜಮೀನನ್ನು ಗುರುತಿಸಿದ್ದಪ್ಪ ಚಿಕ್ಕ ಶಿವರುದ್ರಯ್ಯ ಹಾಗೂ ಅವರ ಅಣ್ಣ ತಮ್ಮಗಳು ಕೊಂಡುಕೊಂಡಿದ್ದು ಕನ್ನೇಗೌಡ ಹಾಗೂ ಪುಟ್ಟಲಿಂಗಪ್ಪ ಗುರುತಿದ್ದಪ್ಪನಿಗೆ ವಿಧಾನ ಜಮೀನು ದಾನವಾಗಿ ಕೊಟ್ಟಿದ್ದರು. ಶಾಲೆಗೆ ಕೊಟ್ಟಿದ್ದು ಜಮೀನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಜಮೀನು ಪೂರ್ತಿ ಹರಿಯುತ್ತಿದೆ. ಗುರುತಿದ್ದಪ್ಪ ವಾಡಿಗೆ ಶಾಲಾ ಜಮೀನನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ದಾನೆ ಎಂದರೆ ನಿಜ. ಶಾಲೆಗೆ ಕೊಟ್ಟಿರುವ ಜಮೀನನ್ನು ಬಿಟ್ಟು ಉಳಿದ ಜಮೀನು ಮಾರಾಟ ಮಾಡಿದ್ರೆ ನಿಜ. ಗುರುತಿದ್ದಪ್ಪ ಇದ್ದವರಿಂದ ಕೂಲಿಗೆ ಶಿವರುದ್ರಯ್ಯ 1 ಎಕರೆ ಜಮೀನು ದಾನ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ಇದು ನಿಜ. ಹಾಗೆಯೇ ನಮ್ಮ ತಂದೆಯವರು ಸಹ 1 ಎಕರೆ ಜಮೀನು ದಾನ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಮ್ಮ ತಂದೆಯವರು ದಾನ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ದಾಖಲೆ ಇಲ್ಲ. ನಿಶಾನೆಡಿ 7ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಜಮೀನು ಚಿಕ್ಕ ಶಿವರುದ್ರಯ್ಯ ದಾನ ಕೊಟ್ಟಿದ್ದು ನಿಜ.
ಆಯ್ತಾ?
ನಾನು ಕೆಲಸ ಮಾಡಿದ್ದಕ್ಕೆ ತಾಲೂಕು ಕಚೇರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. 58ನೇ ಸಾಲಿನಲ್ಲಿ ಕೊಡಿಯಾಗಿದೆ. ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳು 58ನೇ ನೋಡಿವೆ, ನಂತರ ನೋಡಿಲ್ಲ. ನಮ್ಮ ತಂದೆಗೆ ಸರ್ವೆ ನಂಬರ್ 40ರಲ್ಲಿ ಜಮೀನು ಇರಲಿಲ್ಲ, ದಾನ ಕೊಟ್ಟಿಲ್ಲ ಇದು ಸರಿಯಲ್ಲ. ಯಾವ ಜಮೀನು ಯಾವತ್ತೂ ಕೂಲಿ ದಾನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರಲಿಲ್ಲ ಇದು ಸರಿಯಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 40/1 ಹಾಗೂ 40/12 ಒಂದಕ್ಕೊಂದು ಲಗತ್ತಾಗಿದೆ. ಸರ್ವೆ ನಂಬರ್ 40/1 ಜಮೀನು 40/12 ಜಮೀನಿನ ದಕ್ಷಿಣಕ್ಕೆ ಬರುತ್ತದೆ. 40/1 ಜಮೀನಿನ ಚಕ್ಕಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಮೊದಲು ಗುರುಸಿದ್ದಪ್ಪನಿಗೆ ಸೇರಿದ ಜಮೀನು ಈಗ ದೊಡ್ಡಯ್ಯನಿಗೆ ಸೇರಿದೆ. ಪಶ್ಚಿಮ ಅರ್ಕಾವತಿ ನದಿ, ಉತ್ತರಕ್ಕೆ ಹಳ್ಳ, ದಕ್ಷಿಣಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 40ರ ಉಳಿದ ಜಮೀನು. ಸರ್ವೆ ನಂಬರ್ 40/12 ಜಮೀನು ಚಕ್ಕಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಕಡಬಗೆರೆ ಬೆಟ್ಟ ಹಳ್ಳಿ ದಾರಿ, ಪಶ್ಚಿಮಕ್ಕೆ ಅರ್ಕಾವತಿ ನದಿ, ಉತ್ತರಕ್ಕೆ ಕೋಡಿಹಳ್ಳ, ದಕ್ಷಿಣಕ್ಕೆ ದೊಡ್ಡಯ್ಯ ಜಮೀನು ಸುಮಾರು 2 ಎಕರೆ ಚಿಲ್ಲರೆ ಇದೆ. ಈ ಜಮೀನು ಚಕ್ಕಬಂದಿ ಮಧ್ಯದಲ್ಲಿ 40/1 ಜಮೀನು ಬರುವುದಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 40/1 ಜಮೀನು ಮಾತ್ರ ಶಾಲೆಗೆ ಸೇರಿದೆ. 40/12 ಶಾಲೆಗೆ ಸೇರಿಲ್ಲ ಎಂದು ಸರಿಯಲ್ಲ. ಕೇವಲ ಕೋಡು ಮಾತ್ರ ಅದಲು ಬದಲಾಗಿದೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. 40/1ಕ್ಕೆ ಸಂಬಂಧಿಸಿದ RRIL ಪಾಣಿಗಳಲ್ಲಿ ದೊಡ್ಡಯ್ಯನ ಹೆಸರಿಗೂ ಹಾಗೂ 40/12 ಶಾಲೆಯ ಹೆಸರಿಗೆ ಬರೆದಿದೆ ಎಂಬುದು ನಿಜ. ಅದಲು ಬದಲಾಗಿದೆ ಅಂತ ಕೋಡ್ ಮಾಡುವಾಗ ಅವರಿಗೆ ದಾನವಾಗಿ ಬಂದಿರೋ ಜಮೀನು ನಮ್ಮ ಹೆಸರು ಬಂದಿದೆ, ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಅವರ ಹೆಸರಿಗೆ ಕೋಡ್ ಆಗಿದೆ. ವಾದಿಗೆ ತೊಂದರೆ ಕೊಡೋದಕ್ಕಾಗಿ ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇವೆ. ನೆಕ್ಸ್ಟ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ DW3 is the temporary ಶಿಕ್ಷಣಾಧಿಕಾರಿ, ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣಾಧಿಕಾರಿ. In page 6, page 6. Page 5. ಸವಾಲು.
No, come to the next page. ಮೇಲೆ ಫಸ್ಟ್ ದಿಂದ
ನಿಜ ಇಲಾಖೆಗೆ ದಾನವಾಗಿ ಕೊಟ್ಟಿರುವ ಜಮೀನನ್ನು ಬಿಟ್ಟರೆ ಉಳಿದ ಜಮೀನಿನಲ್ಲಿ ನಮಗೇನು ಹಕ್ಕು ಸ್ವಾಧೀನ ಇಲ್ಲ ಅಂದ್ರೆ ಸರಿ. ಸೊ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರುವಂತದ್ದು ಇದು 1 ಎಕರೆ ಮಾತ್ರ, ಉಳಿದದ್ದು ನಮ್ಗೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರಿಗೆ ಒಪ್ಕೊಳ್ತಾರೆ. 2 ಎಕರೆ 11 ಗುಂಟೆಯನ್ನು ಬಿಟ್ಟು 2 ಎಕರೆ 11 ಗುಂಟೆ ನಮ್ಮ ವಿದ್ಯಾರ್ಥಿ ಇಲಾಖೆಗೆ ನೋಂದಣಿ
ಈಗ between 40/1 40/12, what is there in between?
ಅದೇ ಮಧ್ಯದಲ್ಲಿ
ಅಳ್ಳನಾ?
ಇಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ ಏನು ಇಲ್ಲ. ಈಗ 40/12 ಇದರ ಈ 40/1 ನ ಉತ್ತರಕ್ಕೆ 40/12 ಬರ್ತದೆ.
ಅದೇ ಹತ್ಕೊಂಡೇ ಇದೆ.
ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ ಅಲ್ಲಿ ಅಷ್ಟೇ, ಟಚ್ ಆಗುತ್ತೆ.
Correct. It is, there is nothing in between.
ಇಲ್ಲ
ಅಲ್ಲ, ನೀವ್ ಅಂದ್ರಲ್ಲ, they are cultivating some land ಅಂತ.
ಜಮೀನು ಕೊಡಿಸ್ಬಿಟ್ಟು ಬೆಳೆ ಬೆಳೆಸುವುದು ಅಂತ.
ಇದರಲ್ಲಿ 40/12 ನಲ್ಲಿನ
40/1 ನಲ್ಲಿ ಅವ್ರು ಬೆಳೆಸುವಂತದ್ದು. ಇಲ್ಲಿ ಈ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ 40/12 ಅಂತ ಬಂದದ್ದನ್ನು ಅದನ್ನು ಉಪಯೋಗ ಮಾಡಿಕೊಂಡು ಅವ್ರು ನಮಗೆ
40/12 ನಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ?
40/12 ಅಲ್ಲಿ ಅವ್ರೆ ನಮ್ಮ ಬೆಳೆಗೆ ಹಾಳು ಮಾಡ್ತಾ ಇದ್ರು ಮಕ್ಕಳು.
They are not having anything in there. And where is the school? Where is the school situated?
School is situated at distance of 1.5 kilometers.
It's not situated. It is not situated in.
Sketch. ಅದರಲ್ಲಿ ತೋರಿಸ್ತಾರೆ, ಹೊಳೆ ಇದೆ, ಹೊಳೆ ಪಕ್ಕ ಬರುತ್ತದೆ ಈ ಜಮೀನು.
ಯಾವುದು 40/12?
40/12 ಒಂದು ಬೌಂಡ್ರಿ ಹೊಳೆ ಇದೆ,
ಅದು ಪಕ್ಕ ಅದರ ಈ ಸೈಡ್. ಅಂದ್ರೆ 40/1
ನಾರ್ತ್ ಹೊಳೆ ಬರುತ್ತೆ.
40/north ಗೆ 40/1 north ಗೆ ಏನಿದೆ?
40/north ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ 40/12.
ಅಂದ್ರೆ 40/1 ನಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ ಶಾಲೆ ಅಂತ ತೋರಿಸ್ತಾರೆ. So what is the basis for saying that it is school?
ಉದಾಹರಣೆಯಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತದ್ದು ಅಷ್ಟೇ. ಉದಾಹರಣೆಯಲ್ಲಿ any member of the bar find out whether any Hindi is there in this property. I will bear the cost. That is the case. For any reason, if the court finds any doubt about that,
Because it is
fully situated distance. For this purpose only, I have specifically gone to the court and I verified where the school is. The school is situated at distance of 1.5 kilometers. ಅದು ಊರೊಳಗೆ ಬರ್ತದೆ. ಇಲ್ಲಿ ನಮ್ಮ ಇಲ್ಲಿಂದ ಸುಮಾರು ಒಂದು 20-25 ಕಿಲೋಮೀಟರ್ ಒಳಗಡೆ ಇದೆ.
Where is this layer? ಎಲ್ಲಿ ಇರುವುದು this property?
ಇಂದ ಕಡಬಗೆರೆ ದಾಸಪುರ ಹೋಗ್ಲಿ, ಬಿಫೋರ್ ನೆಲಮಂಗಲ ದಾಸಪುರ ಇದೆ. As soon as we reach Nelamangala, before that there is Dasapura. ಅದೇ ಸ್ವಲ್ಪ ಮುಂದಕ್ಕೆ ಹೋದ್ರೆ ಅದೇ ಹುಬ್ಳಿನಲ್ಲಿ ಬರುತ್ತೆ.
ಯಾಕಂದ್ರೆ ಒಂದೇ ಸೇಲ್ ನಲ್ಲಿ ಅಲ್ಲ, ಎಲ್ಲಾ ಸೇಲ್ ನಲ್ಲಿ not the property is shown as the property of the school. ಅಲ್ಲ, property of the school ಅಂತಾರೆ, they don't say school.
ಆತರ ಏನು ಇಲ್ಲ ಅಲ್ಲಿ. For any reason, if the court finds that the court has got any doubt about this, let the commission be appointed. It is the box.
Yes, yes.
Commissioner can be appointed.
Yes, we can appoint.
So what is there in the survey ಕೂಡ ಅವರ ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಸರ್ವೆ ಕೂಡ DDL the court commissioner he has submitted the report, exhibit D19 and D20 ನಲ್ಲಿ ಅವರು ಏನು ಇದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳೋದಿಲ್ಲ, ಜಮೀನು ಯಾಕೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಹೊರತು.
He doesn't say anything what is situated to 40/1.
ಅದರಲ್ಲಿ ಏನಿದೆ ಅಂತ ಅವರು ಹೇಳೋದಿಲ್ಲ. ಹಾಗಾಗಿ to ascertain this fact, the court can appoint any member of the bar and the court only to find out what is that.
Only the landlord has gifted the Mysore Rajapura, but in the school is carried at
That is in respect of 40/1. No, 40/12. The D60 ನೋಡಿದ್ರಲ್ಲ.
There is a code. No one prevented them to, if they are absolute owner, they have to mention the 40/12 also. But in this regard, 40/12, there is a clear narration in the technique. May read ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೆ.
ಅದೇ ಬರ್ದಿದ್ದಾರೆ. ಕೋಡಿ ಆಯ್ತು 18/1/1956.
ಹಿಸ್ಸೆಗಳು ಅಳತೆಯಾಗಿ 1ರಿಂದ 12 ಹಿಸ್ಸೆಗಳು ಈ ಕೆಳಕಂಡಂತೆ ದುರಸ್ತು ಮತ್ತು ಆಕಾರದಲ್ಲಿ ಜಮೀನುದಾರರು ಈ ಕೆಳಕಂಡಂತೆ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ.
The ಹೇಳಿಕೆ, they have mentioned that this is who are in possession and what is that ಅಂತ. ಅಂದ್ರೆ that is how it is. 1919 ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಇದು. By then
56 ಅಲ್ಲೇ ಕೋಡಿ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
56 no dispute ಕೋಡಿ ಆಗಿದ್ದು. This property stands is in your occupation ಅಂತ ಯಾರು ಹೇಳ್ತಾರೆ?
ಇದೇ ಹೇಳ್ತಾರೆ ಕೊಡ್ತೀವಿ ಅಂತ ಮುಂದೆ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ.
ಯಾರು ಹೇಳ್ತಾರೆ?
ಕಂಟಿನ್ಯೂಷನ್ ನೆಕ್ಸ್ಟ್ 2ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಅನುವಾದದಲ್ಲಿ
12ನೇ ಹಿಸ್ಸೆಯಲ್ಲಿ
12ನೇ ಹಿಸ್ಸೆ ಈ ನಂಬರಿನಲ್ಲಿ ಎಲ್ಲಾ ಜನಗಳು ಸೇರಿ ಭೂದಾನದ ಮೂಲಕ ಬಯಂಡಳ್ಳಿ ಸ್ಕೂಲಿಗಾಗಿ ಮೈಸೂರು ಇಂಜಿನಿಯರವರ ಹೆಸರಿಗೆ ಭೂದಾನ ಕೊಟ್ಟಿರುವುದರಿಂದ ಮುಚ್ಚಳಿಕೆ ಪಡೆದು ಇದನ್ನು ಒಂದು ಪ್ರತ್ಯೇಕ ಹಿಸ್ಸೆಯನ್ನಾಗಿ ಮಾಡಿ ಅಳತೆಯಂತೆ 12ನೇ ಹಿಸ್ಸೆಯಾಗಿ ದಾಖಲು ಮಾಡಿರುತ್ತದೆ ಮತ್ತು ಈ ಕೆಳಕಂಡಂತೆ ಇಷ್ಟ ವಿಸ್ತೀರ್ಣದಲ್ಲಿದೆ. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಐಟಮ್ ಇನ್ ದಿಸ್ ದಟ್ ವೆಂಡರ್ ಪುಟ್ಸಿದ್ದಪ್ಪ ಆಲ್ಸೋ his name is also there.
This vendor. Now on what basis he gives this property to you? Gift?
ಅವರು ಇದನ್ನ ನಾವೆಲ್ಲರೂ ಸೇರಿ ಬರ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
There is an agreement, or rather they feel they will give this property to the school. Alva?
We are in possession. Thereafter, revenue records has been entered in the name of the school.
This location of the property is absolutely not in dispute. Location is not in dispute. North gate 40/12 is there, but they say that the property of school ante ಹೇಳ್ತಾರೆ ಅಂತ. ಯಾಕೆ ಹೇಳ್ತಾರೆ ಅಂತ?
ಅಲ್ಲಿ ಮೊದಲು ಕೊಡ್ತೀವಿ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ರು ಅಂತ ಅವ್ರು ಹೇಳುವಂತದ್ದು. ಈಗ 56ರಲ್ಲಿ ಜನವರಿನಲ್ಲಿ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. ಈಗ ಕೊಟ್ಟಿರುವಂತದ್ದು ಎಪ್ರಿಲ್ ಕೊಟ್ಟಿದ್ದು ಬರೀ 1 ಎಕರೆ ಮಾತ್ರ.
Exhibit D9 to D14 ಇದೆ ಅಲ್ಲ? Year of the year?
Year of D9 to 14, 9 to 15. ಅದು 58, 57, 54. D15 is not 54.
ಅದೇ D54 ಆಯ್ತು. D9 to D14.
ಅದು 9 to 14. 57.
ಅದಕ್ಕೆ ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. That's why they said the property to the north side is the school. In light of this exhibit D16, ಗೊತ್ತಾಯ್ತಾ? The exhibit D16 ನೀವು ಎಲ್ಲರೂ ಸೇರಿ ಹೇಳಿದ್ರು ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅಲ್ವಾ? And in light of that, this all documents exhibit D13 to D14 ಹಂಗೆ north side the school ಅಂತ. This court wanted to know that. Exhibit D16. ಅದು 18/1/1956 ಕೋಡಿ ಆಗಿದ ಬಗ್ಗೆ ಬೇರೆ ಎಲ್ಲೂ ಇಲ್ಲ ಅದರ್ ದನ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ, ಬೇರೆ ಯಾವ್ದು ಇಲ್ಲ. ಇಂಡಿಪೆಂಡೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಅಂದ್ರೆ 40 ಇದು 56 ಡಾಕ್ಯುಮೆಂಟ್ ಅವಾಗ ಕೋಡಿ ಮಾಡಿದಾಗ at that time this has happened ಅಲ್ವಾ? ಅದರದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲೂ ಇಲ್ಲ.
Exhibit B19 that also disseminate.
ಅದೇ ಸೇಮ್ ಕರೆಕ್ಟ್, ದಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್. See, ready to be copying. ಎಲ್ಲ ಸೇಲ್ ಡೀಡ್ಸ್ ಇಯರ್ ಹೇಳಿ.
Exhibit D9 dated 21/7/1958.
ಒಂದು ನಿಮಿಷ. 1958. ಆಮೇಲೆ
D10 dated 16/11/1957. D11 dated 2/11/1957.
ಇದು ಫಸ್ಟ್ ಡೇಟ್ 1958 ಹೇಳಿದ್ರ ಡೇಟ್ 21. ಹಾ
16/11/57.
16.
ಮೂರನೇದು
D11.
D11 2/11/57. D12 16/11/57.
16/11/57.
D13 2/11/57. D13 2/11/57.
2/11/57.
D14 16/11/57.
16/11/57. ಹಾ ಗೊತ್ತಾಯ್ತಾ? ಈಗ all this exhibit D9 to D11 are pursuant to this code of the year 1956. And in 1956, they said this property D40/12 would be given to you. And in that pretext, this LD has been mentioned as to the north of
ಇದೊಂದು ಕನ್ಫ್ಯೂಷನ್. ಅದು ಈಗ 48 ವರ್ಷಕ್ಕೆ ಹೇಳ್ಕೊಂಡು ಬಂತು.
ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಡೇಗೆ ಹೋಗ್ಬೇಕು.
At that time it was a small confusion, they could have corrected it at that time itself. But ಹಾಗೆ ಬಿಟ್ಟದ್ರಿಂದಾಗಿ mistake may be small mistake, but unless it is rectified at that stage itself, things will drag on to several years, several decades.
There are additional production documents and all the shadings.
ಅದೇ ಎಲ್ಲಾದ್ರಲ್ಲಿ ನೀವು ನಾರ್ತ್ ನಾಗ ಇದ್ದೀರಿ. ದಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್. ಫಾರ್ ವಾಟ್ ರೀಸನ್? Reason is this 18/1 1956 document, that is ಕೋಡಿ ಆಯ್ತಲ್ಲ. ಕೋಡಿ ಆದ್ಮೇಲೆ ಅಲ್ಲಿ ನೀವು ಹೇಳಿದ್ರು, ಎಲ್ಲಾರು ಹೇಳಿದ್ರು, ಎಲ್ಲಾ ಜನ ಕೂಡ ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ ಅಂತ. ಸೊ they went on saying north ಗೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ, north ಗೆ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ. It is not your contention. ನಿಮ್ದು ಎಲ್ಲಿದೆ ಅದು ಗವರ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ನಿಮ್ದು? ನೀವು ಒಂದು ಸೆಂಟೆನ್ಸ್, how is the issue going to be framed by the trial court that it is an Inam land? Regrant ಬೇಕು ಅಂತ according to you. They have not made an application for regrant. So it is not for them ಅಂತ ಹೇಳುದಲ್ವಾ ನಿಮ್ದು? Endorsement. You know how much it will have value, endorsement. But AAG argued and we felt it is 100% surely. On looking at this sale deeds, we thought it is your property only. No, when you look at all the documents, more particularly the exhibit D16, wherein it is mentioned, you also don't dispute that all of them agreed to give you that land. And in that pretext, this property, if it was this sale deed was before 1956, no, we would have accepted your contentions. It is not all are after 56, all. Yes. ಆಯ್ತಲ್ಲ? ಆಯ್ತು. ಮಾಡಿ. See, we want to resolve the dispute. We want to give justice to party. So we don't mind hearing you once again. ಆಯ್ತು. Tomorrow at 2:30. Choose not the property. ನೀವೇನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಜಜ್ಮೆಂಟಾ? ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮತ್ತೆ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
Only for the assistance of the court. For any reason, court is coming, they ignore answer.
Court forgets ಅಂತನಾ?
ಏನಾಗಿರ್ತಾರೆ with the passage of time.
We will not waste time. That's why we'll dictate.
You target ಮಾಡ್ತೀವಿ ನಾಳೆ we forget it.
That's why we should.
Only case we have to forget. That is the case. Similarly, the court will also be handling thousands of cases. Now only
Yes. They have given their synopsis and you have given your written. Nale. Dictation. Further hearing. Dictation anta beda. Further hearing. Now, this court is tilting towards the respondent. Okay, your basis of argument is endorsement, first. Second, Inam land. Third, this all the sale deed shows to the north of the property is the property of the school. What is the basis? Exhibit D16. Nobody's case. Inam land anta. ಎಲ್ಲರೂ ಬೇಕಲ್ಲ, ಒಂದು ರೆಫರೆನ್ಸ್ ನೀವು ಮಾಡಿದ್ರೆ then the court could have got an opportunity to look at it. ಜೋಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಇದ್ದದ್ದಲ್ಲ. Correct. Boundaries prevail ಅಂದ್ರೆ ಇವ್ರ boundaries ಬಂತಲ್ಲ 9 to 14. ಅಲ್ಲ ಅವ್ರದೊಂದು ಬೌಂಡ್ರಿ ಬಂತಲ್ಲ 9 to 14. ಅವಾಗ ನಮ್ಗೆ we have to just not ignore it, but in light of exhibit D60. On what reason? What was the reason for them to say to the north of the property is the school? The reason is exhibit D60. Not, I don't know. ಅಲ್ಲ ಅದಕ್ಕೆ I asked the sale deeds date. Yes. Tomorrow at 2:30.
End of this matter?
What is this matter? Oh, 23. 23 is the bill. 2023.
They have raised that figure of 3,23,559 more allegation. But under dispute, I have paid 50% of the amount and what is the rest? After that, 1 month after that, again they have disconnected and I am here before this court. Because I have requested them in the year 2022 itself for additional load of 21 kilowatts. Page number 14, annex C. And currently I am having existing load is 24 kilowatts. Since there was during the course of court and there will be more consumption. So I have got the additional load of 21 kilowatts.
You have been using extra now. You have been using extra. That is their contention.
That little extra will be there. That is what I have asked for additional load. This has been, estimation has been drawn. They have conducted the survey and space is provided for installation. Everything is done for our party. But they are not, the estimate has been not matched. He did,
When did they disconnect your electricity connection? No, you had already filed writ petition before this court? And earlier,
certain they are doing, there is a stay order granted in the month of April law. Now,
Irittalina. Which is that order sheet for the order sheet? There is no interim order granted. Then what is the?
now they have issued one more notice, 1819, and they have told me the notice. Again, they say you are due an amount of 1 lakh and 10 lakh 14,000. This notice has
You have to amend the writ petition. You have to file an amended petition by saying incorporating this. This
disconnection. It's right of the say order, not to the order is very much clear.
Where is the order of this court? There must be a restoration of the electricity if disconnected to the petitioner's institution. And the third respondent must take action forthwith. After this, there is restoration, right? And now what has happened after this?
After this 1892 this notice, they have given me 30 days time period. Within a day of sixth day, today morning, during the school hours, they came and again they have disconnected. And this is
where is the date available in this?
I have signed this service 1899. I have signed it. This is undated.
Who appears? We have to at least tell H.V. Devraju. Where is he? Mr. Devraju? They have already disconnected now.
And ask for additional loan.
That is on merits now. This court has already given you an interim order to continue.
This notice contains the electricity bill for the months which have been covered by this interim order. Jan, February, March, I think March 2023.
Mr. Devraju. Mr. Devraju? What is it?
That's for driving. Right from the day I asked for additional load, they are asking me drive. I have the call records yesterday.
Yes, is moved at 2:30 by the petitioner counsel, stating that the respondent, Bescom, in spite of the interim order, in spite of the interim order granted by this court, on 8/12/2023, has disconnected the power supply to the patient premises by the school, where the school has been running. Basis on record the notice issued by the Bescom and received by the petitioner on 18/9/2024, demanding an amount of rupees 1,14,128 by way of this. And it is stated that Petitioner is running an educational institution and 50% back billing rate charges have already been deposited. And this court on 8/12/2023, considering the same, has directed the third respondent to restore the electricity connection if disconnected. Pursuant to the order passed by this court, the petitioner was restored with the electricity connection. And now, by way of demand of the very back billing, which is pending consideration in the present writ petition, the respondent has taken coercive steps of disconnecting the electricity connection. Counsel appearing for the Westcom is not present before the court, though the learned counsel for the petitioner submits that same has been informed to the learned counsel. In the circumstances, we directs the Westcom to restore the electricity connection to the petitioner forthwith. And forthwith. Is the matter for further orders on first. Upload matter. Stop. Really stop. List. Many matters is what is happens is we are in the midst of so much further hearing matters. Serial number 29. Yes, will not argue. Your chance. After this, what is that delay? Proceedings have been abated. It is under the Village Abolition Act or the Urban Land Ceiling? Urban Land Ceiling. So there is some time prescribed, right? On delay. It's on delay.
It's a delay. Or judgment also.
So illegal possession has been taken.
Yes.
Who appears? You appear. Then you take your chance. 2022, right? Take your chance afterwards. Huh? You have to hear it, right? You have to spend time for that. Huh? But where is government? Yeah. Where's the other council? No, he also said there is certain covered matters. Take these matters. Take your chance. After the Dasra vacation in the week commencing from 14. 14. 14th.
Serial number 34, my lord. Sorry, I could not be present. Serial number 34, PF matter.
Yes, yes Mr. Prabhakar, Mr. Subramanya.
I could not be present when the case was called. 34.
After Dasra vacation.
Very good.
Serial number 24, my lords.
34 after Dasra vacation.
24, my lords. May I make a mention?
What is that?
My lords, this is a matter that I had moved yesterday that was substantially and completely heard by my lords last month. It was merely adjourned by a week for the respondents to make any other submissions they had sought as a last opportunity. My lords may kindly give me any date this week. It won't take time at all.
We collected this movement. What is the matter about it?
My lords, this is about the fixed charge demand that we had raised.
It is not even in the further hearing.
My lords had completely heard this matter, my lords. The respondent had sought for
If
time.
at all we had heard this matter, madam, we would have definitely listed this matter for further hearing. It appears that we have not heard it completely and then somehow, anyway.
My lord, may I kindly refresh your memory? May I point out what had happened? Learned Senior Advocate Mr. Sriranga had appeared. This was a submission regarding fixed charge demand that BESCOM had made, wherein there were 2 petitions filed and 1 was withdrawn. And in the second subsequent petition, which is currently pending, it is merely a short charge that is claimed. So the main challenge to the demand was already withdrawn. The other petition has been withdrawn. So my lords, this was the matter and this was heard in detail.
Notes. This list, when do you want?
Any date this week as per my lord's convenience.
This week we are sitting for only on only tomorrow.
Would tomorrow be a possibility, my lords?
Tomorrow we have a further hearing matters. Tomorrow, day after tomorrow. Final hearing. It is in the final hearing list, madam.
Yes,
Anyway,
my lords. My lords.
So take your chance on first.
Grateful, my lords.
My lords, seek to make a mention, my lords. Serial number 36 of list 1, my lords, appearing for the petitioner. Merely seek to have the interim order extended, my lords.
Yes. This matter after Dasra vacation 2024. Ensuing Dasra vacation. Interim order granted earlier is extended to the next date.
Grateful, my lords.
Have been awarded wages, back wages under Section 17, which has accumulated, which has paid up more than 1 crore rupees in 2017. There have also been made attempts to reconcile and release employees back on board.
You are the management. So come this side.
So despite making attempts to reconcile and bring them back within the fold of employees, also they have not respected that. Almost approximately 1 crore rupees has been spent towards reviewing PD.
You have to pay them.
It is
mandatory.
But some resolution to the dispute may happen. Every month that is passed by lakhs.
So now what do you want? What do you want this procedure?
Either next week, either Monday or Tuesday, the matter please be scheduled before the vacations.
So before the vacation, you want to have a Diwali party.
We want to consistently for a month now, matter does not reach anything.
You take your chance after Dasra vacation.
Before the vacation, please allow. Monday or Tuesday.
No, it's not possible, Mr. Counsel. We are not sitting on Monday.
Tuesday, please.
Tuesday first is we have got further hearing matters.
This week any date is not
possible. A court officer is indicating that so many matters are listed. Take it matter after Dasra vacation. We will not see. We will tell you that it will be listed, but if it is not possible to hear this matter unnecessarily, it would be waste of time. So take this matter after the vacation. Yes, after in the week commencing from 21st. Because 14th, from 14th there are only 3 working days. We don't know the next roster. Yes. No, welcome. Rest all only in further hearing. Connecting.
917. 971.
Aduna.
ನಾಳೆ ಇದು ಬೇಕಲ್ವಾ ನಾವು ರೆಫರೆನ್ಸ್ ಟಿ ಸೀರೀಸ್ ಅಂತ